No, no. You mentioned fresh admission orders after notice.
My lord, I may be pardoned. Item 32.
Sir, you have to wait.
I have not obtained the
You have to wait.
the authenticated copy.
I cannot pardon you, Doctor. You have to wait the page to be called.
Page mention page number 1.
गुड़ाक दौरान मेमो लिखिकी दे दियंतु को सीरे आसीबो आपनकर कोन मैटर
मोर टाइम फैमिली को
आपनकर नो आपनकर 32 ना
My matter relating to direction.
अरे फ्रेश ऑर्डर्स
My lord,
after notice.
your lordship directed to the government council to take instruction by the society under the Society Registration Act before the ATM which is pending has not been disposed. My lord.
तेरा केबे को अछि सेटा थिला डेट केबे हेतला
Date, there is no date, my lord.
केमती एमती तो मु करूनी आपण आउ कोर्ट जाइतले कि
admission.
एई कोर्ट तो
This
एई कोर्ट तो सत्य होसी आर यू श्योर कॉन्फिडेंट एई कोर्ट रे डेट हे नतला
this alone court pass the order. The exact
डेट ओ वीक मो तो डेट होनी वीक कमेंसिंग सो आंसर
no, my lord, I have not remember. I will
टी रिमेंबर करिवे ना नले मेंशन करी कोन लाभ लागे का समय नष्ट होला आपण जदी कहि थांते होय त केटा से लेखा काइन आसिलेन जणा पड़ी था we are trying to list all the matters whichever is adjourned to a specific week
my lord,
तो डेली बेसिस रे मैनेज करी हबनी बहुत मैटर रही जो टेम्पल
kindly consider at least.
अरे इतरे अनकाइंड हरे कोन अछि काइंड हरे कोन अछि आपण तो मेमो देले आपण मु पचाली बुझेबे आपण मते मने नै मु कोन काइथे मु कोन काइंड हे परिबी आपण टे काइंडली मने पकेले मु किछि लाभ होंता मो यू आर सो अनकाइंड नॉट टू रिमेंबर व्हाट आई कैन डू से दे मेमोटा ऑर्डर लास्ट ऑर्डर दे 23 हेतला
List in the week comments 23-26.
23-26 पर लिस्ट है
11-2 order.
23 रे काहे की उठावनी फॉर ऑर्डर्स लिखा है नतले
Hearing lecture mention for hearing.
कर ठीक करंतु आपण ऑर्डर्स टाको हियरिंग लिखि दे सिर्फ तळु पळेबो कर दियो फॉर ऑर्डर्स ठीक देखि दे काहे की भी तो आपण तो कोन चपा पत्थर पत्थर जदी देथिले कि उठी परलानी के आपण की चेष्टा करलंती तो
my lord, it is transfer brief, my lord.
ओ ट्रांसफर रे रहि जाइछ ट्रांजिट रे रहला सी जो ऑर्डर प्रथम जो ऑर्डर ता हेतला सेटा आपण अपियर कोन नथिले
No, my lord.
ताले कोन पत्थर पत्थर लदी थे
Page mention page number 1. Item number 1 to 8.
द ऑर्डर से
Yes.
जो सेटा ऑर्डर से
Yeah.
तो हियरिंग लिख दे
Page number 1. Item number 1 to 8.
Number 8.
यस सर
Can it be after lunch?
यस पास ओवर का पास ओवर होची तो
Data. Would like.
Page number 2. Item number 9 to 16. Page number 3. Item number 17 to 23. Page number 4. Item number 24 to 32.
To my lord, I have though obtained the copy of the
Other
payment
side,
showing
sir.
interim maintenance,
Sir,
but I have not obtained the authenticated copy from the bank.
ये काइंडली सुनंतु सर सुनंतु सुनले किछ असुविधा होबन सर आपण सर पिटिशनर ना अपोजिट पार्टी
Petitioner, first bank.
को जणांतु डेट नियंतु जे अदर साइड आसी चारटा बेले कहउछन जागा मु जानिनी मते कहिबी नाहंती तो सेटा एनी ऑर्डर
authenticated गोटे सप्ताह दियंतु मु authenticated copy बैंक रे दे देबी.
अदर साइड भी तो गोटे सी जणे पार्टी आ जणे
हाँ।
वकील तो से फेर ताकर तो फेर किछि वैल्यू अछि ना नै ताकर किछि नै
नहीं अच्छी अच्छी.
हां सो ताको डे वैल्यू दियंतु ए 32 टा डेट करथा तो देखियो
ओइटा दे दो. गोटे नोट टा दे दोछि आज्ञा.
108
200.
अपन
मैंने कोटी
कटिगला.
सिंह 10
हजुर गोटे दे दोछि रिपिन नोट
এটা কাচ এটি ভাঙিବାକୁ পড়িବ এটি সিস্টেম ଆପଣ ରେଜିଷ୍ଟ୍ରି ଫାଇଲ କରିବେ
ऑफ रेस्टिफिल.
ଯାହା ଫାଇଲ କରିବେ ମ୍ୟାଟର ପଡିଲା ବେଳେ ସକାଳେ ଯେ ଏଟା କଣ ହାଜିରା ଯୋଉ ଫାଇଲ କରୁଛନ୍ତି ସେଟା କି
नहीं नहीं सेटा सिलियर.
ଆଜ୍ଞା ଏଟା କେସ୍ ପଡିନି ଆପଣ ଫାଇଲ କରିବେ ସେ ଫାଇଲଟା କୋଉଥିରେ ଟ୍ୟାଗ ହବ ଯୋଉଟା ଦଉଛନ୍ତି
सॉरी यार. एबे
ମୁଁ ବି ଭେରି ସରି ମୁଁ ବୁଝିବାକୁ ଚେଷ୍ଟା କରୁଛି ଆଇ ଅଲୱେଜ ଟ୍ରାଏ ଟୁ ଲର୍ନ Every day I learn something. ଆପଣ ଯଦି ଫାଇଲ କରିବେ ଅଦର ସାଇଡ୍ କୁ କପି ଦେବେ ରେଜିଷ୍ଟ୍ରି ଫାଇଲ କରିବେ that would help you. ଠିକ ଅଛି 10-8 ୱିକ୍ ରେ ଆସିବ ଦେଖିବା ସେ ଅଦର ସାଇଡ୍ କୁ ଆପଣ ଦୟାକରି ଫୋନ ରେ ଜଣାନ୍ତୁ. Let him not wait for the after notice matter.
Page number 5, item number 33 to 39.
40 ଗୋଟେ ହେଲେ
Page number 6, item number 40.
yes call the list.
Item number 1,
pass over.
item number 2,
Mr. Behra,
Yes, ma'am. Yes, ma'am.
AK Behra for the petitioner.
May I please?
Yes, please. Adjournment.
No, no. You'll also last occasion, you'll also direct to me. The matter may be amicably settled between the parties. So my humble prayer, my lord. Okay,
ଆପଣ କେତେ ଟଙ୍କା ବାକି କେତେ ଟଙ୍କା ଅଛି? ମୋର ହମ୍ବଲ ରିକ୍ୱେଷ୍ଟ ହେଲା ଯେ କେତେ ଟଙ୍କା ବାକି ଅଛି 3000 ଟଙ୍କା ଡକ୍ଟର ଇନ୍ ଲୋକୁ 1500 ଟଙ୍କା ଗ୍ରାଣ୍ଡ ଚାଇଲ୍ଡ ଆପଣ ସେଟା ଦବାକୁ ଦଉନାହାନ୍ତି କି ଦବାକୁ ରାଜି ନୁହନ୍ତି ମୁଁ ଏଥିରେ ମେଡିସିନ କଣ କରିପାରିବି ଲେଟ୍ ଅସ୍ ଆସ୍ୟୁମ୍
chance of
ଯେ ପଇସାଟା ଯୋଉ ଦଉନାହାନ୍ତି ମେଣ୍ଟେନାନ୍ସ ପଇସାଟା ଡକ୍ଟର ଇନ୍ ଲୋକୁ ଚାଇଲ୍ଡ
ସେଇଟା
who will mediate for that
if your lordship allow me
ମୁଁ କୋଉ ପଇସା ଦେଇ ପାରିବି
no no my
ଆପଣ ଯଦି ଦେବେ ତାହେଲେ ଡିପୋଜିଟ୍ କରନ୍ତୁ
ଖାଲି notice ଟା surveil
ନା ନା ନୋଟିସ
medicine
ପଇସାଟା ଦିଅନ୍ତୁ ପଇସାଟା ବି ଦବାଟା ଆପଣଙ୍କ କର୍ତ୍ତବ୍ୟ ନା notice ନବା ଯେମିତି ଆପଣ ଆର୍ଗ୍ୟୁ କରୁଛନ୍ତି
I am the father in law my lord.
obviously you have to maintain who else will maintain a widowed daughter in law
ମୁଁ ନିଜେ ତ ମେଣ୍ଟେନ କରିବା ପାଇଁ ବହୁତ ଡିଫିକଲ୍ଟ
ସେଟା କହିଲେନି କାହିଁକି ଟ୍ରାଏଲ କୋର୍ଟରେ କହିଲେନି କାହିଁକି ଯେ ମୁଁ ମେଣ୍ଟେନ କରିପାରିବିନି ବୋଲି କି ସେଟା କହିବ ଟ୍ରାଏଲ କୋର୍ଟରେ ସେଟା କହିବ କିଏ ଯଦି ଆପଣଙ୍କର ବୋହୂ ଏବଂ ନାତୁଣୀ ଯଦି ଅସୁବିଧାରେ ପଡିଲେ ସେମାନେ ଟୁ ପ୍ରିଭେଣ୍ଟ ଦେୟାର ଡେଷ୍ଟିଚ୍ୟୁସନ ଆଣ୍ଡ ଭ୍ୟାଗ୍ରାନ୍ସି ତ କୋର୍ଟ ହାଜ ଆୱାର୍ଡେଡ୍ ଆପଣଙ୍କର 3000 ଟଙ୍କା 1500 ଟଙ୍କା କହିଲେନି କାହିଁକି କୋର୍ଟରେ ସେଟା ଟ୍ରାଏଲ କୋର୍ଟରେ ଆପଣଙ୍କର ଇନକମ୍ ବିଷୟରେ କଣ ପ୍ରିଡିଂସ୍ ଥିଲା ଦେଖନ୍ତୁ ଜଜମେଣ୍ଟରେ କଣ ଡିଲ୍ କରିଛନ୍ତି କୋର୍ଟ କି ଆଜ୍ଞା ହ୍ୟୁମାନିଟି ବି ତ ରହିବ ସେଇ ଯୋଉ ଦି ଜଣ ଆପଣଙ୍କର ତ ଘର ଦ୍ୱାର ସବୁ ଅଛି ଆଉ ଯୋଉ ଦି ଜଣ ଆପଣଙ୍କର ବୋହୂ ଆଉ ଛୁଆ ସେ ନାତୁଣୀ ସେ କୁଆଡେ ଯିବେ
ଆଉ ଗୋଟେ ସନ୍ ସେମାନେ ସେପାରେଟ ରହୁଛନ୍ତି ସବୁ they are living separate.
you have kicked them out have you read the judgment ନା ଯେହେତୁ you will argue I have not read the judgment ଆପଣ argue you have the choice of not reading the judgment what you are arguing what you are challenging
I am only dependent on one
Para 6 ପଢନ୍ତୁ
property, landed property.
para 6 ଟା ପଢନ୍ତୁ ଆପଣ instead of giving a speech try to develop a habit of reading the judgment
ଅଛି
para 5 ରୁ ପଢନ୍ତୁ four ରୁ ପଢୁନାହାନ୍ତି 4 ରୁ ପଢନ୍ତୁ so that you will have a grip of the things because the problem is that what you are arguing and what we are discussing is completely out of context
only my lord dependent
ଆରେ ଆପଣ ପଢିବେ ନା ପଢିବେନି ପଢୁନାହାନ୍ତି para 4 page 25 3 ରୁ ପଢନ୍ତୁ 3 ରୁ ତାକୁ ପାଉନାହାନ୍ତି ନା ନାଇଁ
ନା ପଢୁ ଲାଉଡଲି ପଢି
ମୁଁ ଆପଣ କଣ ଏଠି କଣ ନିରବ ପଠନ ଆପଣ ମୁଁ କରିବା ଏଟା sir, it is a discussion in the court. You have to place it. And what is your argument or contention on that? Judgment ର para 3 ପଢୁ।
humble submission my lord.
ଆରେ ମୁଁ କଣ humble ନୁହଁ?
ପଢିକି ଆସି ପଢିଥିଲି।
ପଢୁନାହାନ୍ତି para 3?
That paragraph 3 man, that after the death of her husband, his father-in-law, mother-in-law, and brother-in-law, along with their caste people, decided that she would marriage with her elder brother-in-law, namely Ramesh Manji. After that, the said Ramesh had kept physical relation with the petitioner for more than 6 months.
କଣ ପଢି ବି ପାରୁନାହାନ୍ତି? Perhaps it is so shocking to you. ଛାଡି ଦିଅ। ଛାଡି ଦିଅ।
So
the matter was presented before this court on 26/4/2022 on 28/10/2025 defects were directed to be removed as it was not removed for the 3 years, more than 3 years, giving ଆପଣ କଣ କିଛି ସତ କହିବେନି କ୍ଲାଏଣ୍ଟ କୁ? Then what is the point in being in the profession? The most best part I have enjoyed. ଶୁଣିଲେ ବୁଝିପାରିବେ। ଆପଣ ତ ମ୍ୟୁଟ୍ ରହୁଛନ୍ତି, ମୁଁ ଯଦି କହିବି ଆପଣ ଇଣ୍ଟରଜେକ୍ଟ କରିବେ। ଜଜମେଣ୍ଟ କଣ ଆର୍ଗୁମେଣ୍ଟ ଆପଣ କହିଲେ ଚୁପ୍ ରହିବେ। ଜଜମେଣ୍ଟ ଟା ପଢନ୍ତୁ, what is your contention on that କହିଲେ ଚୁପ୍ ରହିବେ। ଯଦି ମୁଁ କିଛି କହିବି ତାହେଲେ ଆପଣ ମତେ ଇଣ୍ଟରଜେକ୍ଟ କରିବେ। ଆରେ you have to tell some semblance of truth to your client. When a client comes to you, it is in general, not in this case. I am just narrating my experience, humble experience. The best part of this profession is that you can tell truth on face up to anyone, because he comes up with a case. Honestly, dishonestly, that's a different thing. A person comes to you, the daughter-in-law was compelled to marry the elder brother.
Yes.
Then he has physical relationship. Then all of your family members should kick her out. And then if the court directs for 3,000 and 1,500, they are nowhere actually. Nobody is for them. She could have married elsewhere. She could not have remained in your family. And Mr. Behra, do you think that any lady or girl will tell this in the court in a deposition?
the chance is,
And you are saying about mediation.
the chance is
What on earth can mediator do?
ମୁଁ ତାଙ୍କୁ ସଜେଷ୍ଟ କରିଥିଲି ଯେ ସମ୍ ପ୍ରପର୍ଟି ସେଲ୍ କରି ଦେବା ପାଇଁ।
କରନ୍ତୁ, mediation କଣ ଏଥିରେ ହବ?
ଖାଲି ଗୋଟେ ନୋଟିସ୍ ଗଲେ ସେ ଆଜ୍ଞା
You see, he is not even
ପ୍ରୋବ୍ଲେମ ହଉଛି।
Mr. Behra, you are not treating an individual as a you are not thinking that it is a human soul.
ଆଜ୍ଞା ସାର୍ ଠିକ।
And you are saying that you will mediate.
ସେମାନେ ଖାଲି ଗୋଟେ ନୋଟିସ୍ ନହେଲେ ସେମାନେ ଟିକେ
ତାକୁ ନୋଟିସ୍ ଦିଆଯିବ ଏଥିରେ। Who came to the trial court? Who came to the trial court? They have a decree with them. You don't have a right. You don't have a right to issue notice. Under which provision notice can be issued to them?
notice no
Which provision?
provision
Have you read anything? And I'm sure you are a serious lawyer. I have been watching you. You are a serious lawyer. Issuance of notice will be a burden to the other side because they will never appear. Even after the court directs for 3,000 and 1,500, you want issuance of notice without complying that. You deposit it here. Deposit that amount here.
and I prefer what 2 weeks time to
Nothing, sir.
last chance
4 years. 4 years
last
is enough.
my humble prayer last chance I will tell
My humble understanding is that 4 years is enough.
by the next date
You
I will
have-
definitely
Has the lady launched any execution?
no man.
So she will never launch. You have rose to the occasion, satisfied your counsel, your client,
Yes
and the entire effort of the lady to get something has been frustrated. And to that, To that, more burden is added by the High Court, keeping the matter pending, issuing notice for nothing. And you will not secure follow order 41 rule 3, 38, 10, 11 for deposit of the amount.
Last chance I will take.
Again, last chance ki first, and that's not the point. More than 3 years, giving 3 weeks time, as no one appeared before the judicial lodgment. Thereafter, on 15/1/2026, the petitioner, the learned counsel for the petitioner took further time to remove the defects within 5 working days. On 11/3/2026, the facts of the case as well as the relevant law were discussed, and the learned counsel for the petitioner had adjournment. Again, on 16/4/2026, the petitioner at the learned counsel adjourned the matter. 16/4 and 13/5/2026. Now, after more than 4 years and several listings of the matter, the learned counsel for the petitioner submits that the matter be sent for mediation. To accept the said contention, to consider the said contention, the background facts of the case have to be noted, which have been observed by the learned judge, family court, in his judgment dated. In his judgment at paragraph 2, quote kya dakha nahi, paragraphs 2, 3, 5, 6, judgment. As directed earlier, the petitioner shall file affidavit to secure the amount directed to be paid to the petitioner and the minor daughter. The affidavit shall be filed by filed by the matter shall be listed in the week commencing 27/7/2026. Listed for fresh admission in the week commencing 27/7/2026.
Item number 3.
May I please, your Lordship? Lordship, I am appearing through VC.
Yes.
Yes, here the petition challenge the judgment dated 18/6/2020 passed by the learned family judge and also filed a CRP regarding the matter which is been dismissed.
Instead of resubmitting, kindly go through the order dated 31/3.
Yes, Lordship.
Place the order dated 31/3.
Yes, and the second paragraph. Yes, it has been all been verified, examined.
Sir, you have to read it, place it so that you get the
Yes.
context.
The learned counsel for the petitioner was heard at some length on being asked whether the pleading before the learned judge, family court, that is plaint filed before the petitioner, written statement filed by the opposite party, evidence laid by the petitioner, PW, and the statement of the OPs and the exhibit marked before the learned judge, family court have been examined. The learned counsel seeks time for the adjournment.
Yes.
Yes, Lordship, if, we have collected everything regarding the arguments and the written statement. Everything is with me. So the mere ground is the maintainability. In the ground of maintainability, the learned court below has dismissed my petition for the maintenance.
Sorry, could not hear you.
Dismissed my petition for the maintenance.
Yes.
So with that regard, we have filed this application so that notice may kindly be issued and he may be heard.
So you have to argue for that. I am not
Yes.
inviting for issuance of notice. Kindly
No,
argue on
Lordship,
merits. Because
Lordship, in
scope of
this
revision
matter-
has to be considered.
Yes, yes. In this matter, the petitioner
Which
is
part-
the second wife.
Which part of the judgment you are aggrieved? Place that.
Yes. Kindly may I have glance on the page 20, annexure, that is paragraph 8.
Start with para 7.
Yes.
Evidence.
The petitioner been examined herself as PW1 stated in her evidence that she is the second married wife of the opposite party and the marriage has been solemnized on such 4/7/1999 at Ma Ambika Temple, Baripada, according to the Hindu rites, and declaration of the marriage was executed on the same day before the notary public, Baripada, and the first wife of the opposite party, namely Anita, had consented for the second marriage of the opposite party with the petitioner.
So
To that
kindly
effect
mark that. Kindly mark that.
Yes, yes, Lord. Yes,
So
Lord.
it is your
Yes,
own
Lord.
statement.
Yes, Lord.
So you recognize your marriage is during subsistence of the first marriage. You know the first wife, and
No,
you say that the first wife has consented. I have married, but that is besides the issue. The reason being, you are saying that during subsistence of the first marriage, you have married the person. So that is your own admission. Then read further.
yes. Affidavit before the notary
Namely,
public to
Anita
that
had
effect.
consented for second marriage.
Yes, yes. Anita had consented for the
affidavit by
second
notary
marriage of the
public.
opposite party. Yes. To ill luck, as she is unable to become pregnant again after the birth of the second daughter, for which she permitted the OP for the second marriage. The mother of the petitioner also supported the version for the petitioner regarding the marriage for the marriage of the petitioner with the OP. During the examination of the OP, yes. During the examination of the OP, resulted in the allegation of the petitioner regarding the marriage with the petitioner.
Refuted the allegations.
Yes. Fact of ill treatment and torture on the petitioner. The wife of the OP,
I
Anita
don't know,
Prasad.
Mr. Samal. Some of
Yes.
the words either you are missing or they are not coming.
So, okay, I am repeating, Lordship, I am repeating the para 8 again. During the examination, the OP refuted.
Or is not there during examination.
Yeah, during examination, the OP refuted the allegation of the petitioner regarding his marriage with the petitioner and denied to the fact of the ill treatment and torture on the petitioner. The wife of the OP, Anita Prasad, who is the OP number 2, has denied to the fact that she has consented to the marriage of the petitioner of the OP.
So therefore, come to the last line.
Yes.
Even if it is presumed for the sake of argument. About
Yes.
8-10 lines, even if.
Yes.
Start reading from even if.
Even if it is presumed for the sake of argument that the petitioner has married the OP, the marriage cannot be said be legally valid marriage. At the first wife of the wife was Alif, and hence the marriage between the petitioner and the OP during the lifetime of the first wife of the OP is not lawful in the eye of law. Therefore, it cannot be said that the petitioner is legally married wife of the OP and the marriage is void in the eye of law.
So what is your response to that?
Yes, Lordship, so in this matter, the lower court has observed this.
What is your
But-
response? Lower court, I have
So
made
my-
you to go through and place it. So what is your
Yes.
response to that?
Yes, as per the response is that she has admitted that by the consent of the first wife only, she got married.
It's not a question of consent or what is your response to the finding. Again, then you have forgotten the finding
Yeah.
there. Kindly read the finding. Even if it is presumed,
Even it presumed that the sake of argument the petitioner is married, has married the OP, the marriage cannot be said legally valid marriage. The first wife of the wife was Alif, and hence the marriage between the petitioner and the OP during the lifetime of the first wife, the OP is not valid, is not lawful in the eye of law.
so what is your
So-
response to that?
The if first wife is
That finding,
Alif,
whether this court or as a law, I mean, what is your argument that for this court to interfere with that finding?
Lordship, in this matter, the first wife got pregnant.
Sir,
Then
what
after
you are
the-
arguing, sir? What you are arguing? You are arguing pregnancy of the first wife.
No, not
So,
first wife. The
kindly
second
again,
wife,
kindly
the
again, here
petitioner.
if you are unable to recollect the question, then kindly write it down. What
Yes.
is your response to the finding of the learned trial court, learned family court, that you cannot be the legally married wife of petitioner or the opposite party? So, what is your response to that finding?
No, I can be a legally married wife, Lordship.
You can be okay.
Yes.
In response to the
Uh,
finding of the learned judge family court at paragraph 8, that paragraph 8 रे देखिए court, even if it is presumed up to void in eye of law, this is reported in so and so. Godse, Badshah versus Badshah versus Saubhagyavati, Urmila Badshah, Godse and others. Stop. Court hela. It is submitted by the learned counsel for the petitioner that the petitioner can be the legally married wife. Yes, how he can be legally married wife?
Lordship, if in the law says that in the said judgment, the law says
Sir, if the law says it is a case law or a section or a provision in Hindu Marriage Act,
no,
or it's a speech.
No, it's as an observation by the Honorable Apex Court.
Yes, kindly show the apex court where it has said that during subsistence of the first marriage.
Lordship,
Kindly show the observation of
this-
Supreme Court. Which decision?
Lordship, I have to research in it. There is a observation,
No,
so
sir,
I have to find it.
This is not World Cup football. That's
No,
round robin, then elimination 16, then quarter final, semi-final, final.
Lordship,
Either it
can
is
I
there,
have
Mr.
in the
Mr.
same
Sahoo.
in the same
Mr.
judgment, in the same
we are
judgment.
we are not having a football match. We are in serious business of considering law. So you have
Lordship, in the
because
page 12 only.
Mr. Samal, these points
Yes.
were argued. We are in revision. So if
Yes, sir.
then what was your stand that it can be valid marriage before the trial court, that you have to show.
Lordship, in the same judgment only.
kindly show that.
I so in the same judgment in the page
Later we
12,
go there.
the court. If a man and a woman having living together for a long time, even without a valid marriage,
Sir, you are adding you are adding married man.
Yeah,
That what you
yes,
are
Lordship.
introducing married is as a devastating consequence.
Yes, Lordship. Lordship,
So,
kindly have.
so how
yes.
can you say no? Because you are introducing some word which is not there.
So
Your
if-
interpretation
so
of a man and woman having living together for a long time, even without a valid marriage, the term valid
Yes.
marriage entitling such woman to maintenance should be drawn.
Yes, Lordship.
So
Yes,
he's a
that
married
is
man.
married man.
He's a married man. And now come to your plaint. Because you have examined everything, come to your plaint.
Yes, Lordship.
What you have stated regarding your marital status with the opposite party.
In the first paragraph, the first paragraph, the petitioner
Because I am
is
not
the
having
second.
that. So you have to.
In the Lordship, so I have stated that the
Hmm.
petitioner. So I have stated the petitioner is the second married wife of the opposite party,
So stop there.
and the
So-
marriage is
So you have been claiming to be the second married wife of the
Yes.
opposite party husband. So
Yes.
now go. In fact, there is no other stand on your part. So now come back to
Lordship,
what you are reading now. Just go back
yes,
to what you are reading now.
actually, yes. Solemnized on 4/7/1999, I'm reading that the petitioner is the second married wife of the OP and their marriage was
So that
solemnized
much
on
is enough. That is your
4/7/1999
stand. So leave it there,
at Ma
Mr. Samal.
Ambika Temple, Baripada, according to Hindu rites
Mr.
and
Samal,
declaration of
Mr. Samal, kindly listen. You have pleaded that
Lordship,
you are the second
only
married wife and claiming maintenance. Now go back to the
yes,
judgment where you have left. Therefore, it cannot be said
yes,
that.
yes. Yes, so, in the judgment, Lord.
Where you have left reading.
Yes.
Para
Therefore,
20.
it cannot be said that the petitioner is a legally married wife of the
Is
OP
A, no, is the.
and is the, as I am saying, the wife of the OP and their marriage is void in the eye of law, as per the decision reported in the Batsa versus Urmila. That is,
Kindly read that.
the Honorable Supreme Court had laid down that the right of a maintenance of second wife in the Indian under this certain condition allowed maintenance to the second wife basing on the following observation. The observation is, if a man and woman having living together for a long time even without a valid marriage, the term of a valid marriage entitling such a woman to maintenance should be drawn, and a woman in such a case should be entitled to maintenance under section 125 CRPC. Then a false representation was given to the respondent, that he has a single and was competent to enter into marital tie with the respondent.
He was single.
He was single. The petitioner cannot be allowed to take advantage of his own wrong and deny maintenance to his second wife. For the purpose of the section 125 CRPC, respondent would be treated as the wife of the petitioner.
Respondent 1.
Yes, respondent 1 would be
3 and 4,
treated.
which are very relevant.
Yes, respondent 1 would be treated as the wife of the petitioner. And the third point, the wife was unaware of the first marriage of the husband. Yes, in this point, unaware.
Sir, I am not asking your explanation.
Yes,
Because you have stated it, so you cannot explain it now.
Yes, and the purpose of the
So now
section
the problem
128
is that 1, 2, and 3 all are against you
yes,
because of your own statement.
yes, Lord.
Now what else?
So
In Godse versus Godse, all 1, 2, and 3 are against you because your own statement is that.
And the second wife.
Mr. Samal, actually, it is not that you may be entitled, but as a lawyer that you have to think, because I have gone to this side, I can very well imagine how you are entitled and what you can do. But you are discussing 125, scope of 125.
Yes,
And if you apply Badsa versus Urmila Badsa Godse, you have no case. Because not only you have pleaded that, you have also stated in your evidence.
Yes.
You have been cheated or you have been treated unfairly, that part is fine. Which enactment takes care of this situation? According to you? There are enactments. Or at least one enactment is there which takes care of this kind of situation. And it's
So
a
I'm not
clear
able
case
to-
of wrong legal advice.
Yes.
Because you not only chopped off the branch you are sitting, you seriously damaged your own both legs. You filed a 125 application stating that I am a second wife, I am aware of first wife leaving, I have obtained consent from the first wife. To this extent, you have damaged your case. It's a clear case of wrong legal advice and absolutely, I mean, self-defeating pleadings. Suicide goal to आठु better ହେଇଥାନ୍ତା. ଆପଣ କିଛି at least pleading ଟା ଠିକରେ ରଖିଥାନ୍ତେ. You are having a case as if the case could be. You can't improve now. Yes, today or some other day you want.
So I want another day so that I can do research
So,
on.
so there is no case, Mr. Samarth. You are just keeping the matter pending, and since 2022, you have kept it pending.
So I may be given one more chance.
Because
so that
maintenance can never be a res judicata.
Yes, Lord.
So since 2022, for nothing you have kept the matter pending here. The lady would be thinking that she would be getting something, but when you on your own you have filed affidavit, on your own your pleadings are that you have stated on oath before the learned trial court that you are the second married wife. The concept
Yes,
of
Lord.
second marriage after 1955, the lawyer, any lawyer worth his salt should be aware of that. And if you ask that whether this is impossible, it is definitely possible. That is happening in our society. But you should not have, you have barked up, in fact, you have barked on the wrong tree. ଆପଣ 125 ରେ ଚେଷ୍ଟା କଲେ ପ୍ରୁଭ୍ କରିବା ପାଇଁ that you are the wife and you are entitled. ସେ ଯୋଉ ଗୋଡସେ versus ଗୋଡସେ କିଏ ସାଇଟ୍ ଆପଣ ସାଇଟ୍ କରିଥିଲେ? ନା
So
ସେଟା
at that time, so I have no power in this case.
No, I am not saying that as a lawyer. ଆପଣ ମାନେ as the
Yeah.
petitioner ସେଟା କାହା କିଏ ସାଇଟ୍ କରିଥିଲେ?
Petitioner ଦେଇଛନ୍ତି in the sir.
ଯଦି
So I am
petitioner
not
ସାଇଟ୍
aware of
କରିଥିବେ
that.
ସି ବି ଗୋଟେ ସେଟ୍ ସେଟା ବି ଆଉ ଗୋଟେ ଦେଲେ ସେଟା ଆଉ ଗୋଟେ ମାନେ ଯୋଉ ଟିକେ ବି ଥିଲା ଆପଣଙ୍କର semblance of chance. Godse versus Godse is completely against you.
Yes,
All three
yes, Lord.
ingredients. The learned counsel for the petitioner refers to the earlier order dictated. Order stated 31-3-2026. High Court counsel for the petitioner. The learned counsel for the petitioner refers to order dated 31-3, order stated 31-3-2026 and 29-4-2026 and submits that he has gone through the pleadings of the parties, the evidences laid, the examination in chief and cross-examination before the learned judge's family court. On being asked, the learned counsel takes the court through the judgment dated 18-20 by C, paragraphs
7 and 8.
Six is also relevant because to save time, paragraph 6, 7, and 8.
Yes. The pleadings of the petitioner as well as the evidence laid considerately goes to show that she was aware of the first marriage of the opposite party. Though she has stated that she has stated that she married the opposite party, but during subsistence of the first valid marriage, she has further stated that she had taken consent within court, consent of the first wife. That would itself show that the petitioner being aware of the marital status of the opposite party. The learned trial court has referred to the judgment of the Hon'Ble Apex Court, citation Badshah, BADSHAH, page 21 versus
Saubhagya SOW. SOU, sorry, SOU. Saubhagyavati. SOU dot Urmila Vatsa Godse. GODS. Wonderful. The Lorded Family Court has relied on the decision of the Honorable Apex Court in so and so and so. देखिए लिखिए. Citation यदि मिलियो आपको दिया. Page 21. Wherein at Roman small 2 and Roman small 2, 3 and 4, the following has been observed. Applying the above principles as elaborated in Godse Supra, Godse Supra. The Learned Family Court has correctly held that the marital status of the opposite party, she not being single and married, was well within the knowledge of the petitioner. So, at this stage, the Lord Counsel for the petitioner seeks further time to advance arguments. The matter shall be listed for fresh admission in the week commencing. How much time, Mr. Saman?
4 weeks, at least to prepare.
2 weeks.
4 weeks.
Suvilani.
4 weeks, Lordship.
4 weeks. 4 weeks.
4 weeks. 4 weeks. 4 weeks.
4 weeks. You are adding the insult to the agony. More injury you are doing. You should not. You should have been careful in filing this appeal and keeping it pending for 4 years. These kind of situation has been taken care of now. The legislature has realized this. 125 is long back in 50s, early 50s, or maybe before that. But thereafter, the legislature has provided for this kind of situation. Only the matter shall be listed in the week commencing.
No.
No. Week commencing 3/8/2026.
Item number 4.
Upon ଯେତେବେଳେ ଗୋଟେ କେସ୍ କରୁଛନ୍ତି ସବୁବେଳେ ମାନେ what is happening to the petitioner, where she stands, or what is happening to her, and how you are creating a hope in her, the whole process. So you have to tell her the truth. ଆପଣ ଏମିତି ପକେଇ ରଖିଲେ ସେ କେବେ କେସ୍ ଫାଇଲ କରିଥିଲେ? ସେ ଫାଇଲ କରିଥିଲେ ଟ୍ରାଏଲ କୋର୍ଟରେ 2022 ରେ। 99 ରେ ତାଙ୍କର ଦେଖ 99 ଧରଲେ ତାଙ୍କର ଏବେ ହେଇଗଲାଣି 27 ବର୍ଷ। Just imagine her plight. At least you should have thought immediately that what I am telling you, that under which provisions he can get. Anyway.
4. In item 4,
Yes, please.
there was a chance of settlement.
No, there was a chance. What my friend says, I think it will all be settled because, of
It
course.
can be settled.
No. Only selling lot six. Please put him down.
I have given an offer. He has.
No, he has not given an offer at all.
Mr. Balkrishna, ଆପଣ ବହୁତ ବ୍ୟାଙ୍କ କେସରେ ଆକ୍ୱାର କରୁଛନ୍ତି, ସେଥିରେ OTS କରି ଆପଣଙ୍କର ଅଫର ଦେବେ. So that you will do, but that is not applicable in matrimonial matters is concerned. ଆପଣଙ୍କର ବର୍ତ୍ତମାନ ଅଫର ମାନେ କଣ କହୁଛନ୍ତି?
To settle it as one.
କଣ ସେଇଟା? କଣ ସେଟା ତ ମାନେ ହିଡିନ୍ ହେଇପାରିବନି। ବ୍ୟାଙ୍କରେ ସିମ୍ପଲ one time one OTS ରେ ଆପଣଙ୍କର 15 ଲକ୍ଷ କ୍ଲେମ ଅଛି, ମୁଁ ଆଜ୍ଞା ଦେଇଦେବି, ଆଉ ଏତେ ଟଙ୍କା ଲୋନ ୱେଭର ଏତିକି କରିଦିଅନ୍ତୁ, ଇଣ୍ଟରେଷ୍ଟ ୱେଭର କରିଦିଅନ୍ତୁ, ସେଇ ଟାଇପର ଆର୍ଗୁମେଣ୍ଟ କଣ ଏଠି ହେଇପାରିବ? ଆପଣ କଣ କହୁଛନ୍ତି କ୍ଲିୟରଲି କୁହନ୍ତୁ. Let me understand what you are saying.
Petitioner says he is ready and willing for 10 lakhs. He will give 10 lakhs
As permanent alimony.
permanent. That's
Mr. Samantray,
No.
since this relationship has no future, the way things have progressed,
No.
it becomes like I have been discussing.
The other case, please.
Mr. Samantray, you being the leader of the bar, the petition should have been filed in Domestic Violence Act, Financial
Right.
Assistance.
Also given and the
फाइनेंशियल असिस्टेंस बट से सेठी पूरा फुल फ्लेजेड आर्गुमेंट कर देले मु ताको वाइफ
with
टुडे
consent.
कोर्ट रो भी चॉइस नहीं फुल फ्लेजेड बट मिस्टर सामंतराय दिस हैपेंस इन आवर सोसाइटी
Oh, obviously.
many
With the
times
consent
you
of
find
your first
consent especially in case of infertility
That is the only ground, Lord. Infertility is the only ground.
and you'll find many judgments of at least one judgment of Supreme Court where infertility cannot be a ground for
Second.
cruelty because many times tankara mane because he is of course infertility kaharo seta be out jinso many times the lady is attributed unnecessarily
Yeah.
and unfortunately many
Yes.
times because of disease and all that also fertility is affected. So it cannot be a ground that desertion and the wife is cruel. So that cannot be.
Yes.
But he tankara pura ekdam full fledged petition file kole lekhile sabu evidence bhi dei dele.
Very simple.
I think more of the understanding, whatever little I understand, they should have filed a DVA financial assistance. Jutre ki the this definition of ba nohele 125 रे ओटा फाइल करिवार नथिला. कोन करथाने सेटा अलगा कथा.
Ground nature and otherwise
अलगा ground से अलगा कथा.
said household ground.
What? Even 125 maybe in fact without recognized marriage they have.
Yes.
But she claim kale mu wife. गला तांगर इतिगा. पण देखंतु 10 लाख
Yes.
कोचि मते ते कम लागुची मिस्टर आपन कैपेसिटी टू अर्न एंड आपन जो
What
आपन उतरे बाहले
again?
Se bahagi chuagi se मतलब
अच्छा.
he is living happily.
No, he's not living happily. His second wife also expired in corona.
Is that a ground for living unhappily?
No.
For third marriage.
Third one.
Obviously it has to be third marriage.
Yes.
First marriage expert हे गला. Second marriage भगवान ताकू कर देले.
नहीं होले. So for third marriage.
तापरे थर्ड मैरिज हे परियो कुछ असुविधा नै.
Third one is
आपण टिके मिस्टर
So, just
आपण तुषार मिश्र को आणंतु.
no,
आपण निजे कहले होतो से आपण ता सुनिबे. आपण कहले से वेल नोन टू यू फैमिली ना कोन.
related to
ठीक अछि.
So let him give him a reasonable offer so that he can be settled.
what I humbly submit. Let it come through the horse's mouth. Let it be referred to the mediation center.
सर जी सुनो
That is my opinion.
you
So
are under
once
a,
and
you are
for-
under a you are under a completely wrong notion that when the judges and lawyers version is
Right.
not working, mediators version will work.
And mediator is
Mediation
your
is
lawyer, he will
overburdened.
not settle it.
Mediator is overburdened and he doesn't have this authority to say something legally. Mediator आपण कहि परिबे किछि कहि परिबे किछि कहि परिबे. यानी ताकर आपनकर इतरे you are this is a case you are challenging the maintenance awarded.
Yes.
The mediator कोन कहि? Does he have scope?
No, he
किछि नै.
doesn't have.
टू आपनकर मेंटेनेंस रे हाई कोर्ट रो भी स्कोप नै कहे पे रिवीजन रे बट आपण जेतु कहउछंती इट इज एज इफ आई एम डीलिंग इट विथ ए मैटर रे सिंगल जज का जुरिडिक्शन नै आपनकर कंसर्न आपण जोडा प्रथम रु कहले से नोन टू मी एंड दे आर इन डिफिकल्टी देन मिस्टर सामंतराय appeared and he says that expiry decree for a she is now suffering and I mean she doesn't know आपण expiry decree नेइथिले बोलते आपण प्रॉब्लम रे पडिले नले से काई फाइल आपण नेले सेटु श्रीकाकुलम ना कोठी
आगे.
नेलोर रे so this is a very peculiar fact so mu etre in fact if you ask me about mediation by कहउछंती what mediation I can refer in a revision quantum
I made a submission.
no आपण जे आपण मते गाइड करिवे ना I have to be educated in law by you आपण ए जो आपणकर ए जो whatever award has been made सेटा को आपण सब केते टका टोटल हेलानी ड्यू
Sir, due to beginning ରୁ ଦେଇ ନାହାନ୍ତି.
तथापि अंदाज
Sir, 2 ଲକ୍ଷ 2.5 ଲକ୍ଷ ଟଙ୍କା ତ minimum.
सेटा तादे सबस्यूम हे जिवो तो सेटा भी ठीक भाबंतु आपण जदि ओटा ऑफर देबे आई कैन आस्क मिस्टर सामंतराय दैट से 2.5 लाख टका जा हेची ड्यू अछि छाडंतु
Let him put up. I'll intimate whatever he says reasonably.
नहीं, he says 10 lakhs.
you are behaving as if you have won the case
No.
there is a decree against you see आउटी आगु कहउतले मिस्टर बारिक बेहरा कहउतले अगर नोटिस इशू करंतु
I leave it.
See,
I leave it.
you, by leaving to me, I cannot do anything because it is only
No, it's true.
obviously what I will do. Only you have to. Have you deposited that amount here?
No. Heighty nahi, kooti nahi. And Lords, so because of your lordship's order, the trial court is not taking up the matter for attachment of salary, lords, even though notice was issued. And she has not got a single pie even after that order, lords.
My lord, can I suggest one thing? Let it be
Before
taken.
suggesting, you kindly go through the order dated 25/2026. You must not forget that it is a maintenance application which I am dealing with. Sorry, 23. Kindly place it.
Can it be taken upon a week, 1 week after, so that I will ask Tushar to make his submissions?
No, you have to respond to that. I can't wait for Mr. Tushar for the 3 months. I waited for you, both of you, for 4 months.
Yeah, only a week. Only I asked him for a week.
Definitely, but what is happening now? Even this court is partly to be blamed. On 23rd March, I heard the matter. I made the observations and noted everything. Now in month of July, still I am sitting over it. It is not in your case, Mr. Balakrishna. You would have marked that I am not sitting over many revision matters. There is a purpose because there is a order. The execution is interdicted. There are decisions of apex court directing for disposal of execution matters. Then who is responsible?
True, man.
I have to take the responsibility as a court,
Nah,
not as individual.
Nah, I was waiting
So
for my
anyway,
friends.
You see,
Only a week after.
No, Mr. Balakrishna, you must note that your client's assumption are unrealistic. In a revision application, he wants to settle for the alimony and get. Then he doesn't. Honor the decree of maintenance without any ground.
Everything within after 1 week, I will do it. Let it be
Then
on
the only argument, serious argument by both of you, I think you must have
20th,
consulted.
week commencing 20th.
So it was not the serious argument. The only serious argument we commencing 20th was not the serious argument. Only effort of both of you was that divorced wife cannot get 125. So that is completely wrong. It's completely contrary to statute. So
Lords, may I
the matter
suggest
was
I'm suggesting my friend is so lords, let it come on, we come on 20th. Let him raise the offer because he says that 10 lakhs.
ଶୁଣନ୍ତୁ ଏଭଳିଆ ଯୋଉ ମାନେ ୱିନ୍ ସିଚୁଏସନ କାହାର ହବନି
Okay.
ମାନେ ମେଣ୍ଟେନାନ୍ସ ରିଭିଜନ ଫାଇଲ ହବ ସେଥିରେ ମ୍ୟାରେଜ ସେଟଲ ହେଇଯିବ ସୋ ସେଇଟା ମିଷ୍ଟର ବାଲକୃଷ୍ଣ ଜାଣିଛନ୍ତି ଆପଣ ବି ସେଥିପାଇଁ କନସିଡରିଂ ୟୁର ଏଜ ଆଣ୍ଡ ଏକ୍ସପିରିଏନ୍ସ ଆଣ୍ଡ ଷ୍ଟାଚ୍ୟୁର ଆପଣ ବି ଜାଣିଛନ୍ତି ବଟ୍ କଣ କରାଯିବ ସେ ଲୋକ ରାଜି ହେବା ଦରକାର ହି କ୍ୟାନ୍ ନେଭର ଗେଟ୍ ଏ ବେଟର ଦ୍ୟାନ୍ ଦିସ୍
Yes.
Asu Puditaru, sir, I will.
and ବର୍ତ୍ତମାନ at least the third marriage will be at stake ବୁଝିପାରୁଛନ୍ତି କି ଫାର୍ଷ୍ଟ ଏକ୍ସପର୍ଟି ସେକେଣ୍ଡ ଟା ଭଗବାନ ଥାର୍ଡ ଟା ଆପଣଙ୍କର ସୁବିଧା କଣ ହବ
Without recording my question.
No, listen, you have to listen.
Let her come.
You have to. No, I am not inviting anyone here.
No. He says that she is my wife. So her second wife expired. Let her come.
Why should he?
Why
You have
should-
abandoned her since so many years and now she will
You are
keep
imagining too many things.
No,
Always when you enter the courtroom, leave the concepts given by your client. Come here. So I am again and again reminded of my senior telling about Bimal Krishna Pal.
Pal.
That when so and so argues in so and so's court, can I give an example? The Bankan? The well, like, the learned counsel for the petitioner was heard at some length regarding the various possibilities that can lead to a settlement between the parties. But the learned senior advocate, Mr. L. Samantray, along with Mr. Jitendra, today Mr. A. Sahoo,
Asutosh.
Mr. Ashutosh Sahu, the appearance of apparent Mr. P.V. Balakrishna for the petitioner, Mr. L. Samantray, senior advocate, along with Mr. A. Sahu.
Sir, dita case achi. 141 re I am the
Yes,
petitioner.
first lekhi diyantu. Secondary, Mr. A. Sahu, along with Mr. L. Samantray, along with A. Sahu for petitioner, Balakrishna for the opposite party. Kote order sheet koriyo. That is the order habare hai. Or contact appearance for. Party stop. Is submitted by the learned senior advocate for the opposite party, wife in RPFM 118 and petitioner in 141. Say RPFM, statement accused. That in the present case, the amount directed to be paid as maintenance by the learned judge family court is yet to be complied with. But the learned counsel for the petitioner is again apprised of the detailed order dated 23/3/2026, wherein the submissions on behalf of the petitioner seeking revision of the judgment dated 27/25 have been noted. The facts as well as the propositions of law have also been noted in detail. Somehow, Mr. Balkrishna, I had a hunch that this will lead to such a situation. So that is the reason I recorded everything on the first day. Because it will be easier for you also. Because they don't listen to you. Like at length. Full stop. Para. Alright, counsel for the petitioner 6 and has adjournment. The matter shall be listed in the week commencing.
20th.
Both the matters shall be listed in the week commencing. 27 or 26. Pursuant Korantu, Mr.
I will put Lord. The offer is yours.
I mean, it is very difficult for her. It will be difficult for her, but only solace should be that there will be no further this litigation, and
Yes, sir.
that way you can explain her.
Item number 5.
I on behalf of my
Madam?
sir. Item number 5.
Please tell your name.
Manisha Vishwa.
Mrs. Manisha Bishwal on behalf of Vidyadhar Mansingh
Yes, sir.
for the petitioner. Mr. BP Pradhan for the
Sir, it is
Mr. DN Lenka IGA for
The family court.
OP number 2.
1. Mr. BP Pradhan
OP number 2.
for OP2. Yes, madam.
my lord, item number 5 permitted to withdraw.
Memo देବାକୁ ପଡିବ. Memo ଦିଅନ୍ତୁ ଲେଖି. ପାୱାର ଅଛି ତ? ମାନେ ଯାହାଙ୍କର ପାୱାର ଅଛି ତାଙ୍କର ଦସ୍ତଖତ ଆଣନ୍ତୁ.
ଆଜ୍ଞା.
ହଁ. Yes, Mr. Pradhan, permitted to withdraw. The ନାଁଟା ଲେଖନ୍ତୁ ଆଜ୍ଞା. ସବୁବେଳେ ଏ ଯୋଉ ଇନିସିଆଲ ମାରିବେନି. Bracket ରେ ଲେଖିବେ. You are not there. Justice Ganguly, he used to frown upon this sort of signature. ସେଥିପାଇଁ ମାର୍ଜିନ ରେ କାହିଁ actually ଯୋଉ ନାଁ ଲେଖାଯାଏ signature it's like bank ପୁରାଟା ଲେଖିବେ. 2016. The petition has the petition has been filed seeking transfer of GR case number 871 of 2025, pending before the Learned JMFC Jatani JTNI Jatani to the Learned Court of Learned JMFC Bhubaneswar staff. Today the matter being listed for fresh admission. Memo of date is filed by the Learned Counsel for the petitioner. As if not, memo of date is filed by the Learned Counsel for the petitioner, which states thus. The memo shall be taken on record, scan copy be updated. About a copy to the Learned Counsel for the OP number 2 is made aware of the memo. It shall be taken on record, scan copy updated. The Learned Counsel for OP number 2 is made aware of the memo. The petition is disposed of. What is the staff?
Again. Item number 6.
Mr. Pavitra Kumar Behra. Mr.
May
Behra.
I please?
Pavitra Kumar Behra for the petitioner.
This case, my lord, present petitioner seeking a direction to transfer the GR case number 1082/2022 from the
से GR केस टा फाइल किए करथला
आज्ञा
GR केस टा जो हैला फाइल किए कले
हमें होची कंप्लेनेंट ये
तला तो आपण कंप्लेनेंट कथारे केमती आउथरे आगड जाको ट्रांसफर हो
हमें वर्तमान केंद्र
जते बेले जोटी चाहिबे को प्रोविजन सर
आज्ञा हमर फैमिली को
आज्ञा आपण टिके लॉ विषय रे कोन आज्ञा जहा क्लाइंट फुटू सुनी काले कबाट बंद कला बेले एठी पूरा लॉ को प्रोविजन रे जते बेले जोटी चाहिबे सेठी केस होबो कंप्लेनेंट जोटी आज फाइल कले कटक रे काली पिटिशन फाइल कले भुवनेश्वर रे काना हमें रहूचू सेटा जोटा कहिबे सेटा कथा रे कुआ जायनी लॉ रे कुआ जाय लॉ माने को लॉ
I am mentioning, my lord. I am submitting. I am submitting the grounds, my lord.
ग्राउंड्स नुह प्रोविजन सीआरपीसी जानचंदी
Yes,
बर्तन कोन हेची
the BNS.
हूं
BNS.
तार फुल फॉर्म कोन
भारतीय न्याय संहिता.
भारतीय
न्याय संहिता.
भारतीय न्याय संहिता होची आईपीसी सीआरपीसी ता कोन हेची भारतीय नागरिक सुरक्षा संहिता सो सीआरपीसी रो को प्रोविजन रे आपण से रिलाय करी के एटा फाइल करछन सेटा कोन
Yes, no problem. I am not mentioning the ground provision, my lord.
Okay.
This is
You are Mr. Pavitra Kumar Behra.
my lord.
The petitioner in the petition by filing the application seeks transfer of the GR case number 14802022 from the Court of Law at JMFC, Raukela to the Court of Law at JMFC Kendrapada. On being asked, the Learned Counsel for the petitioner submits that the provision of law under which the application is sought for, the transfer is sought for, has not been mentioned, as it would be available in the Criminal Procedure Code, Code of Criminal Procedure, 1973 into brackets since repealed and substituted by Bharatiya Nagarika Suraksha Sanhita 2023. The Learned Counsel for the petitioner has adjournment to bring to the notice of the court the provisions on which, the provision based on which order transferring of the proceeding can be directed when the petitioner herself had filed the complaint case before the ଆପଣ complaint pass କରିଥିଲେ ନା ଆପଣ ଇଏ FIR ଦେଇଥିଲେ?
FIR.
Has filed a FIR on 13/8/2022 in Raghunathpalli PS, which was registered as PS case number 229 of 2022 under section 498 into bracket capital A, oblique 341, 323, 294, oblique 506, oblique 354, oblique 34 of IPC, and section 4 of Dowry Prohibition Act. चाहिए देखिए लिखिए पेज 4 में भारत के लिए. It is also it is also stated that the investigation was completed and summon to witness has been issued in GR case number 1480 of 2022 from the learned JMFC Raukela. It is submitted by the learned counsel for the petitioner that the petitioner now stays at Kendrapada. Therefore, she seeks transfer of the trial to Kendrapada. In considered opinion of this court, the trial cannot take place at the place of residence of the witnesses, as that would lead to a situation where the place of occurrence, the competent court having trial, competent court doing the trial cannot be disturbed, considering the residence of the convenience of the one of the witnesses. जो ट्रांसफर होची फैमिली कोर्ट मैटर सेडा ता भीतर को भर्ती कर दिलानी. क्रिमिनल ट्रायल रे आपन के सब कांसेप्ट नाही जे जोटी रहिबे आपनकर somebody may shift, somebody may travel, somebody may go away.
Then petitioner is suffering from various diseases, my lord. He is unable to appear.
सेटा ट्रांसफरेबल कोठी अछि. प्रोविजन ता तो पर देखिबे. The learned counsel for the petitioner further submits that the petitioner suffers from various diseases and she cannot attend the court at Raukela. The learned counsel for the petitioner has adjournment to verify the provisions of law as well as case law, particularly the law laid down by the Honorable Apex Court, to entertain such contention of the petitioner. The matter shall be listed for fresh admission in the week commencing 10/8/2026.
Your Lordship, see the annexure 3, page 13. One TRPC has been filed by the present petitioner before this honorable court. In this case, in particular this case, the opposite party has already appeared and he has consent. He has a consent. He has no objection if the case is transferred from Raulkela to Kendrapada.
कौन टा ट्रांसफर हो?
सेटा होची CP केसटा.
कौन हो?
Divorce filed by the husband.
So divorce it is between a lease inter parties, दी जण पार्टी. आपण केस रे पार्टी के?
केस रे
आपण होचंदी विटनेस, सी होचंदी प्रोसिक्यूशन.
माय
तेणु सेमती CPC द प्रिंसिपल भर्ती करंतुनी. मु मते भल लागो आपण कथा सुनै पे जदी लिखि देबी मोर गला फेरे सुप्रीम कोर्ट कहबे non application of mine. 498 केस टा ट्रांसफर हो जोठी कंप्लेनेंट रहइबो कि विटनेस रहइबो एटा अपन तो लॉ डिवॉल्व हेनी. कारण मु भी चेष्टा करछि पढिया पे आपण मानन संग.
Item number 7. Item number 7. Item number 9.
Item 8.
So प्रधान आपण के मेंशन करथिले.
ना ना मेंशन माने आफ्टर डिस्कस
रे कहिसले 500 को दे दीटा.
ओ अच्छा अच्छा.
Item number 8 इटा.
एक पे करो शासिल. तो संजय कुमार item 8 पे संजय कुमार प्रधान for the petitioner.
The petitioner is the husband was challenging the impugned judgment dated 11/12/2025 to a limited extent for not holding the wife living in adultery while deciding issue number 3. That is the
What was your evidence देखा तो? आपन evidence कौन थिला? अगर written statement देखेबे.
sir.
written statement, your lordship may kindly see this counter, page 30, annexure 2.
ଆପଣ adultery ground କୋଉଠି ନେଇଛନ୍ତି?
Yes. Lords, it starts from para 5, Lord, page 32. Second para. In fact, the opposite party was transferred to Naval Dockyard, Visakhapatnam on 28 September 2011 and started living in Meghadripeta.
अरे आपण straight away go to the paragraph where you have
Yes.
alleged
Lords,
adultery.
Lord.
ଆପଣ ନିଜ transfer କଥା କଣ କହୁଛନ୍ତି?
Towards middle of that
Where-
para, your lordship will find.
whether you seriously allege that and prove that. So that is
Yes,
the point.
yes, my lord.
That you have to show.
That I've heard and also
କୋଉଠି ପଢନ୍ତୁ straight away ଜାଣିଛୁ?
T. Surya Rao, who is a salesman in CSD
Hold on.
canteen area depot at Meghadripeta, Visakhapatnam,
ଏତେ ଜଲ୍ଦି ପଢିଲେ କେମିତି ହବ? ମୁଁ ତ ଆପଣଙ୍କ ଭଳିଆ ଥରେ ପଢି ପାରିଲେ ହବ?
middle of that
ହୁଁ, ହୁଁ।
defense center, namely Suruchi, and indulged in extramarital relationship with him
ହଁ
with the active support of her mother and her brother.
ଠିକ ଅଛି statement ଦେଲେ. Now what is your evidence and what is your examination in chief ରେ କଣ କଲେ ଦେଖାନ୍ତୁ?
Examination in chief, Lord, you are not.
କାହା କି proof କଲା ଟି ସୂର୍ୟ ରାଓ ସାଙ୍ଗରେ?
Yes, page 56.
I am at 56 only. Straight away go there.
Page 56. Para 4. Para 4.
ଆଗ 2 ରେ ପଢନ୍ତୁ ଆସ. 2 ପଢନ୍ତୁ.
That after our marriage, while we were staying in Kolkata since December 2009, I found her talking with a stranger on her mobile phone regularly and even in midnight with a paramour over mobile most of the times. Then
So you have not specified anything. ଆପଣ ଯାହା ସାଙ୍ଗରେ କଥା ହେବେ ସେଟା ଭଲ. ଆଉ ୱାଇଫ ଯାହା ସାଙ୍ଗରେ କଥା ହେବେ ସେ ପାରାମର.
paramour,
You have to be specific. ଏଟା କଣ? This is a matter of joke before a court or what?
Lord, I specifically,
Whenever you are making allegation, you have to be serious.
I produced a pen drive.
Kindly, हाँ, then सेटा गला, para 2 गला. तापरे कोठी कहले?
Para 2, then para 4, my lord. Para 4, after birth of my lord, about 4 lines from the top. After birth of son Aditya on 29/9/2014, she started avoiding me and developed intimacy with one T. Surya Rao, who is a salesman in CSD canteen area depot at Meghadripeta at one tiffin center, namely Suruchi, and indulged in extramarital relationship with him with the active support of her mother. On 21/11/2016 of the petitioner number 1 and her mother and petitioner number 2 and 3 were taken to Vijayawada by T. Surya Rao in his car on our marriage day. But they
So
did not.
if the wife travels with in a car, that is extramarital affair, according to you.
Lord,
So what you want to? ଆପଣ କଣ proof କଲେ ସେଟା କହିବେ ନା
I
ନାହିଁ?
produced. Lord,
ରାତିରେ ମୋବାଇଲ ରେ କଥା ହଉଥିଲେ, କାର ରେ ଗଲେ. So that amount to extramarital affair.
Lord, I will show your lordship the finding part. Lord,
No, ଆପଣ ଆଗ pleading ସାରନ୍ତୁ ଆଗ. ଆପଣ ଆଗ pleading ସାରନ୍ତୁ, ଆପଣ pleading discussion ରେ finding part.
Lord, petitioner taken to in his car marriage day, but they
So you are say ଆପଣଙ୍କର evidence ହେଲା ଯେ ସେ ମୋବାଇଲ ରେ କଥା ହଉଥିଲେ, ଅବଶ୍ୟ ଆପଣ ନାଁ କହୁନାହାନ୍ତି. ଟି ସୂର୍ୟ ରାଓଙ୍କ ସାଙ୍ଗରେ କାର ରେ ଯାଇଥିଲେ.
Car ରେ
That is amount to
car ରେ ଗଲେ?
ମାନେ according to you that is amounts to extramarital affair. ଠିକ ଅଛି. ତାପରେ
Lord, then Lord, later on 7/6/2017, I suddenly came to my house from office for collecting some office documents which were forgotten. And I found both the petitioner number 1 and T. Surya Rao in one of his main bedroom in a position of holding each other without dresses. After seeing that position,
ଏଟା
I
କୋଉଠି
became,
ଆପଣଙ୍କ ଘଟଣାଟା ଦେଖିଲେ?
Lord, date I've said 7/6/2017.
Okay.
then
ନାଇଁ
absolutely.
ଆପଣ ସେଟା ସେଣ୍ଟେନ୍ସ ସେଟା ନାହିଁ ତ ଆପଣଙ୍କର ଯୋଉଟା କହିଲେ they were in a
Yes, compromising
position.
Well, after seeing that position, I became shameful and my mind became dull as I could not expect such kind of ugly scene directly by my naked eye in the main bedroom, and it also shocked me.
Yes, ତାପରେ
After getting
ଆପଣ cross examination ଦେଖାନ୍ତୁ
my second paragraph, cross-examination, running page 63. I filed one pen drive containing CCTV footage and
ନାଇଁ ଆପଣଙ୍କର
network.
ଟିକେ ରୁହନ୍ତୁ 63 ହଉଛି ଆପଣଙ୍କର cross examination.
Yes.
ସେ ପେନ୍ ଡ୍ରାଇଭ ଟା ଆପଣ ତ କହିନାହାନ୍ତି ଏଥିରେ ଚିଫ୍ ରେ
Chief re
କାହିଁ ସେଟା କାହିଁକି it has to be rejected?
my submission is that section 14 of that family court said says, I'm reading out. Section
Pen drive will be admissible.
Application of Indian Evidence Act has been how it is.
So the law will be given a go by.
No,
Anything and everything is admissible. When you do not say something in your pleadings or examination in chief.
Counter.
So you should have averted that, but not to spoil your case.
Application of Indian Evidence Act. A family court may receive as evidence any report, statement, documents, information, or matter that may, in its opinion, assist it to deal effectually with a dispute, whether or not the same would be otherwise relevant or admissible under the Indian evidence.
So, apanaga problem is you have adduced that. Family court has not received that.
Received.
Adduced. Apanaga, you are interpreting that any evidence is admissible. It's a question of admissibility that the court has that the section does not say so.
Whether or not the same would be
because there is no such evolution of law that in family court matters CPC and Evidence Act will not be applicable. Anyway, ଆପଣଙ୍କର ଯୋଉ ସେ ଆପଣ ତ ଯୋଉଟା କହିଲେ ଆପଣ ଯୋଉଟା ଦଉଛନ୍ତି ପେନ୍ ଡ୍ରାଇଭ ରେ ଷ୍ଟ୍ରିଟ୍ କଣ ଏଥିରେ ସେଟା ତ ଷ୍ଟ୍ରିଟ୍ କିଛି ନୁହଁ ଏଟା ତ ଲୁଜ ଆପଣ ଦଉଥିଲେ କାହିଁକି ସେଇଟା
ପେନ୍ ଡ୍ରାଇଭ
ପେନ୍ ଡ୍ରାଇଭ ରେ ଦେଲେ ଆପଣଙ୍କର ଆଡମିସିବଲ କେମିତି ହବ
65B
65B ଦେଖନ୍ତୁ
65B it says
electronic evidence.
No, Indian evidence.
Electronic evidence देखिए pen drive is electronic evidence.
It has been discussed. It has been stated in the 65B.
पढ़न्तु.
Sir,
I am asking you something else.
Cases in which secondary evidence relating to documents may be given.
ସେଇଟା ଆପଣ ସେତେବେଳେ ବୁଝଉଥିଲି ଏଟା ଡକ୍ୟୁମେଣ୍ଟ ନୁହଁ electronic evidence. Never cite before citing a provision which is not with you, don't cite that. Is it a documentary evidence? Pen drive.
No, it's a electronic
So
evidence.
it's not a documentary evidence.
65, not 65B. Sorry. So I was wrongly placing 65. It's 65B. Admissibility of electronic records. notwithstanding anything contained in this act, any information contained in an electronic record, which is printed on a paper, stored, recorded, or copied in optical or magnetic media produced by a computer, shall be deemed to be a document if the conditions mentioned in these sections are satisfied in relation to the information and computer in question, and shall be admissible in any proceeding without further proof of production of the original as evidence of any contents of the original or of any fact stated therein, of which direct evidence would be admissible.
So how it is against you? It is completely against you.
Look,
65B does not say that the evidence shall be produced without being asserted by the person producing the evidence. You did not refer to that because that is a problem. If you say something at the stage of cross-examination which is not there in your pleadings or in your examination in chief in affidavit, how the court will evaluate it? 65B doesn't exempt that from you.
That 65B.
Suppose you have a provision in Evidence Act which will say that evidence can be adduced and entertained at any time. Then CRPC jodi thibo. I am not aware. I am yet to be educated to that extent that evidence can be taken up at the whims and fancy of the court first, second at the sweet will of the parties. Now suppose your wife in this case gives evidence, states something and produces a pen drive. What would be your answer? The same answer as we are discussing. You have to tell that to the other side why you are invited to the doc to state that. In doc, what you are stating in the examination in chief, that will be confronted to you. Many times 164 statements recorded in criminal matters, are they helping the trial?
No.
They are not. The reason being 164 statement is not made in the doc. It is the examination in chief in evidence which was made in the doc.
That holds.
But somehow the police act, many times you will find that after 161, they take the witness to the magistrate and record 164. 65B does not relevancy, admissibility, weight, जो जिनसोड़ा basic, I mean what you call the first principles of evidence.
Right.
It doesn't become relevant solely because it is contained referred in 65B. And 65B to prove is another difficulty.
65B.
Electronic evidence.
65B, 4 milords. In any proceeding where
Mr. Pradhan, actually, at least I am enjoying the discussion.
Right.
But thanks to
Yes,
that you have read and making the
I'm
points.
pleased.
The other part is that electronic evidence has a problem of veracity. Like suppose there is a seizure in case of some contraband is seized. Now, if it is not seized and sealed and properly sealed, if it is transferred, then the prosecution, the defense will question it. That there is a chance of contamination or somebody else interfering.
Right.
So electronic evidence has that problem also.
It has to be certified.
It has to be not only certified, who has recorded what is, at each step. Suppose the pen drive contains a photograph.
Right.
The photographer has to be examined. Who took the photograph? It is just like earlier.
65
Earlier also.
Right.
So that part I was trying to draw your attention that
Right.
not only you have to say in your evidence,
Right.
then you have to prove the entire thing.
Only mistake, the petitioner has committed that he has not taken that pen drive word, milords, in that.
Mr. Pradhan, not only that, this is the over enthusiasm of the lawyer. Whenever the person came with a pen drive and said that the lawyer should have thought, because if you introduce electronic evidence like pen drive, the first question the defense will take, other side will take that what is the authenticity? Because you should not spoil your own case.
Right.
That you have done. No, kindly look at the cross-examination.
65.
Page 65. Page 65. 65 for podi.
65(4), in any proceeding where it is desired to give statement in evidence by virtue of this section, a certificate doing any of the following things, that is to say, so and so, and purporting to be signed by a person occupying a responsible official position in relation to the operation of the relevant device, number one,
So that
or the management of the relevant activity.
so that you are
Yes,
saying.
I am coming- I am
what
coming
we
in
are,
that
what we are discussing that you are saying.
Well,
So unless that certificate and all this
I am
essence is
coming
not
in
there.
the second part. I am coming. Or the management of the relevant activities, which is appropriate, whichever is appropriate. It is not an official document. It's a, I have installed the CCTV. I have recorded.
Whatever, sir, whatever. But the problem is that if you want the like photographs were entertained, voice recording is entertained. Prior to entertainment of this pen drive and CD or whatever, since time immemorial, messages were entertained, telephonic evidence, suppose a voice is recorded. So there is a method of proving that. The method cannot, the court is not, scared of accepting evidence. The court is having a difficulty in entertaining evidence which is contaminated or there is a possibility of contamination. That is the situation.
Latest Supreme Court decision, my lord, that is 2025. It says,
Mr. Pradhan, always you have a decision that the pen drive can be introduced at the stage of cross-examination.
pendrive electronics কথা ଅଛି, magnetic chip কথা ଅଛି.
At stage of cross-examination, say jo electronic ta, at the stage of cross-examination, upon introduce karibe, seta koti achi, seta we are stuck there. ଆପଣ ଆଗ ଯୋଉ ଆପଣ ଆରମ୍ଭଟାରେ କ୍ରସ୍ କରିନାହାନ୍ତି ଆପଣ 65B ରେ କଲେଣି ମାନେ ପ୍ରୁଫ୍ ଆଡକୁ 65 ରେ ଆପଣ ଆଗ ପ୍ରୋଭିଜନ ଟା ଦେଖନ୍ତୁ ଯୋଉଥିରେ କି ଏନି ଷ୍ଟେଜ ୟୁ କ୍ୟାନ୍ ଇଣ୍ଟ୍ରୋଡ୍ୟୁସ ଦ ଏଭିଡେନ୍ସ ସେ କଥା ଡିସ୍କସନ ଚାଲିଛି which I asked you importantly that either in Evidence Act or CRPC that at any stage of trial the evidence can be introduced or who can introduce. So that is not there. Can you look at the page 65?
Page 65. It is fact that my brother is a.
No, just look at, I'm looking at 65 only to find out anything, any reference was made in cross-examination or any questions were asked to you regarding this.
Pen drive.
That Vijayawada is the adulterous relationship. Your wife and her mother were accompanying T. Surya Rao. That you have admitted in para 31 and 32. 30, 31, 32.
Para 31.
36, 32. Page 66, 67. Her mother was there.
Yes, all have been all right.
Her mother was there.
Yes. She is supporting her son.
So that is your interpretation. You are saying that mother is supporting her to have an adulterous relationship. Being
My mother-in-law.
Correct. Her mother.
Yes. With the department, we were deciding at the entry gate, one register is maintained to make entry regarding entry and the exist of strangers to the apartment. One written complaint before the state officer of the apartment regarding the incident dated 7/6/2017, where I called the petitioner number 1 with the Surya Rao.
38 पढ़ो.
I have tried to inform the incident dated so and so to the police, but they did not accept my report as the incident occurred within defense area. I have informed the incident to the state officer on the same day. It is a fact that
CCTV अच्छी से
installed on the entrance gate of the colony where we were residing.
40.
The CCTV camera postages footages
were not recovered after my complaint to the state officer on the colony.
The same was also not recovered by the police.
So that they extracted from you that this is not that CCTV footage.
No. CCTV
footage
I have installed in my house.
The primary evidence is that there is a institutional CCTV. You have your CCTV.
Man,
And you say that I have recorded everything which you do not disclose. And you admit that yes, there is a CCTV, I did not ask or it was not recovered. Then kindly read further.
it is a fact that I have not filed any certificate regarding the authenticity of the contents of the pen drive submitted by me in connection with the present proceeding.
That clinches, it's gone. That is how the trial is so interesting.
Certificate was given.
38, 40, 39, 40. Upon the statement given I cannot, even if you have given, I cannot entertain. You must understand the limitation on part of a court. When you say that I have not given,
That is there in the judgment.
ତାପରେ ଆପଣଙ୍କର 44 ରେ ବି you have some other ଇଏ.
$49. Watchman has been also examined by me.
That you have denied actually. You have said that I do not remember who was the watchman. That is the other problem. What did I say that?
Neighbors. But the
What is the status of the marriage now? How the parties are living?
She is residing in
When you have filed 13, why you are not filing application for divorce?
Divorce is pending.
This is 125.
She has refused to live with me without
125. This is 125.
120.
What is the divorce pending? What is the status of the divorce case?
So I had initially filed in Visakhapatnam. Later it was transferred.
But unless you secure the amount, I will not issue notice.
Well,
because you have tried to vilify your wife. You have not been successful in doing that.
Well,
and there are some apparent. You have a apparent situation. You believe very things strongly. So that is the reason I was asking you that maybe you should get divorced.
okay.
So now, unless you deposit, I will not issue notice.
112, page 112. Finding part. Just
then upon discussion, I'm going there, but I'm just going through your entire evidence. You have two children.
yes.
They are staying with your wife.
With wife to knife, the maternal uncles.
You are not maintaining your children?
Well,
Are you maintaining your children?
yes, I'm paying
How much you are paying?
10,000 in total, 5,000 each. Whatever has been directed by the learned court. I'm paying regularly. There is no issue.
Have you filed that? You give the details how much you are paying to the children.
Yes, I will give. Each month, never defaulted. Paying regularly.
Total amount directed?
Maintenance has been refused to the wife, and so far children are concerned, below 5,000 each has been directed.
The court has not directed any maintenance to wife.
No, because she has voluntarily refused to live with the without reason.
I was seriously for last almost 40 minutes I have been listening to. I was thinking that you are arguing on that point of adultery. Then why you are arguing adultery here?
Yes, not
If the wife has not been granted maintenance,
yes. Yes,
I might have learned, but we have spent so much of time.
yes, that
For children, you are resisting.
no, not
Then you
resisting.
give the wife has not been awarded any.
That-
Are you sure?
issue has been framed. Let's pay 118.
Let me check. I should
118.
have checked the ye portion, not any portion.
118 you know. Page 118. Operative portion.
Yes. Then why you have been arguing adultery?
Issue has been framed, but the learned court says that
Read some judgments on 125. The family court cannot enter into that aspect.
but
The,
issue has
the,
been,
the other problem is that you, Mr. Pradhan, you are so serious. I thought that you are arguing that because no
because
case, Mr. Pradhan.
voluntarily refused to stay with
Sir,
you.
that for that you have to argue in 13. This is not a
13
scope.
is pending.
125 scope is very well defined.
But my point is, my lords, issue has been framed.
Sir, why you are depriving a lawyer of his fees? Let him file. I thought that since I was you are so serious, I have been reading and going on examining the evidence.
That part, my lords,
But
I was trying to.
but to be, I mean, you have right now you know that I didn't mark that you have not been awarded. The wife has not been awarded any
Yes.
maintenance.
Right.
Nothing.
Lords, your lords, me. That
No, you
part,
have done your part. We have discussed. So,
my lords, go take this.
Mr. Again, another first principle is that no court should enter into any adjudication which does not have to be determined as far as the ultimate decision is concerned. The court cannot give a finding in 125 whether she is leading adulterous or normal life when the maintenance is not awarded.
Maintenance,
then
has been denied on other ground.
Whatever.
On other ground.
Whatever.
But fact
At
remains.
least you should be satisfied that you have been
Yes,
successful in
stated about-
editing that.
there is-
Leave it there. ଆପଣଙ୍କର ଯୋଉ କେସ୍ ରେ ହବା କଥା ହବ ନା।
112 ଟିକେ just put a paradigm 112 second para. So far the evidence of OP husband regarding CCTV footage is concerned, the footages relied upon merely shows the petitioner wife and an unknown male person sitting in the drawing room and sharing food in one clip. The petitioner number wife is seen to be slightly hogged from back.
That's not a mistake on part of the. That is a mistake on part of the family court. The family court should not have entertained inadmissible evidence. Should not have like the way I have been listening to 45 minutes. The court got mesmerized. What was the point for discussing that when it has not been admitted and examined?
65. My point is.
ଆପଣଙ୍କର CCTV footage ଟା admit କୋଉଠି ହେଲା? By which order?
65.
When it was proved?
No, the
CCTV footage ଆମେ ଦେଖୁନୁ କି? ଧରନ୍ତୁ ମୁଁ ବର୍ତ୍ତମାନ ତଳକୁ ଯିବି ଦେଖିବି CCTV footage. Can I admit that? Even what I see myself, I cannot.
certificate, so far certificate is concerned, I am the person who has installed. Therefore, I have given the certificate. at a later stage. Later stage.
You tried your luck. You got evidence. ଆପଣ ତା 113 ର ସେକେଣ୍ଡ ପାରାଟା ପଢନ୍ତୁ ସବ ପାରାଟା the CCTV footage indicating ସେଟା କ'ଣ
Whatever the
so over enthusiasm of your lawyer has done this. The CCTV footage is indicating isolated gestures of familiarity or closeness without convincing or corroborative circumstantial evidence are wholly insufficient to sustain finding of adultery 125(4). This you invited only. Now the wife has not challenged anything, and this observation, considering the CCTV footage itself, is on error apparent on the face of the record. By which order it was admitted as evidence? How 65B was complied with? It has not been.
for that.
Now suppose why it will mark in everywhere where there is a CCTV. Why it is written in big letters under CCTV surveillance? Why it is written? For whom? Because even it is notified also. Please appreciate that. So Sanjay Kumar Pradhan, for the petitioner, opposite party blank. The revision application has been filed. With the following prayer.
Shall I make a?
ଆପଣଙ୍କ petition ଆପଣଙ୍କର did you make a counter claim there?
No.
Then that is another huge problem. In her petition, how a finding can be given declaring her to be adulterous?
That
Which provision? 125 which provision? In 125 application, her claim can be rejected, can be allowed. To the following prayer. The judgment dated 11/12/2025 was rendered in the application in CRP number 14 of 2019. Stop. The CRP was filed by the wife in the marriage and two minor children. Daughter aged about 8 years and son aged about 5 years. As petitioners 1, 2, and 3, seeking monthly maintenance under section 125 CRPC at the rate of
yes, no. For the wife, she sought for 15,000.
15,000 at the rate of 15,000 for the wife and rupees 5,000 each for the two minor child. By the impugned judgment, no monthly maintenance was awarded to the wife. Both the children were awarded to be both the children were directed to be paid monthly maintenance at the rate of 5,000 towards their maintenance and educational expenses.
Wife was refused to.
The opposite party for the Lord Judge Family Court, as petitioner in the present application, as husband in the marriage, is before this court. Challenges the judgment of the Lord Judge Family Court to the limited extent as indicated in his prayer quoted above. The Lord Counsel for the petitioner was heard at length. And he argued the matter with ability, referring to the provisions contained in the Indian Evidence Act and Code of Criminal Procedure. Stop. The relief sought for in the revision application is that the Lord Judge Family Court. You can take your seat, Mr. Pradhan.
No.
Anything else you are saying?
Yes.
You are saying anything else?
Yes, but wife was refused maintenance on the ground that she refused to join the husband.
Whatever. The problem is that if a finding would have been given against the wife and she would have challenged, the entire order would have gone. If you evaluate it on the basis of the material on record, admissibility of evidence, and whether the court should go into those aspects without examining without admitting the evidence by order and examining by applying 65B, it would have created problem for you. Or like, should have given a finding regarding the adulterous conduct of the wife. As a matter of fact, the adulterous conduct of wife was an issue. What issue of author dikhele? Judgment.
No,
Adulterous conduct of
page 113.
13 issue achi. Na issue jo frame hai 1 2 3 4.
Oh, yes, yes.
Seda dekha.
Lord's page 94.
94.
Para 4.
As an issue as would be noticed in the issues framed by the Learned Judge Family Court at para 4 of the judgment. Para 4 page 94 achi. Internal page 13. Para.
Roman 3.
To substantiate the after framing the issue at Roman 4 dot at 4 dot Roman 3 small triple I, the Learned Court has not gone into the said aspect, as would be evident from the judgment that the Learned Court has refrained from granting any maintenance to the wife, though marriage was not disputed, the birth of 2 children was not disputed, and there was evidence of the husband not maintaining the wife and children. Stop. The ground of such denial of maintenance to the wife is she voluntarily deserting. Ko jayar likhile apna kuchhle?
Lord's, your Lord's will find 100 page 115. 115 second para. Para 14 second para.
I'm getting there.
It has continued up to 116 also.
Granting maintenance to the wife. She voluntarily deserting the present petitioner husband in the marriage.
Towards middle. First part.
At paragraph 14 of the judgment, subpara in page 116.
Yes.
So 16 to the following effect. In following words of the Learned Family Judge Court, the assertions made by the petitioner number 1 wife in her pleading and her corresponding evidence are not sufficient to assign a good cause to her for her refusal to live with OP husband. When the petitioner number 1, page 116 the assertion to arambo hi ki up to CRPC. It is submitted by the learned counsel for the petitioner that the petitioner does not challenge the maintenance granted to the two children. And as per his instructions, the wife as well as the children have not challenged the judgment of the learned family court directing payment of maintenance to the children. So, now this court has to consider and answer whether in the 125 in the proceeding under section 125, the learned judge family court was under a duty to either accept or reject the plea of adultery, allegation of adultery made against the petitioner wife made by the husband. From perusal of the judgment, it is apparent that though the evidence has been discussed to a certain extent, regarding which this court expresses no opinion whether such evidence was admissible or not, but the court has not given any finding regarding the allegation of adultery made by the husband. In considered view of this court, there was no occasion for the court to give a finding regarding the adulterous conduct within court, adulterous conduct as alleged by the petitioner, by the present petitioner husband against the wife. The petition is accordingly disposed of.
Item number 9.
Mr. Pradhan, now the judgment is over. One more question. Suppose let us assume that the court gives a finding regarding adulterous conduct. Because court actually has struggled also. The court has struggled that it could not find anything. That is the reason it has not. But court was perhaps thinking that the lady is in adultery.
It is a fact.
Could
It's
be.
out of-
No. Say that.
Out of-
Mr. Pradhan, never make a statement like this because you can't be judgmental. You are not the witness at their house to see the adulterous conduct. Never go by any version, at least in public.
No,
Never.
contest about
Don't
that.
say that. That's not the point. But by the court recording adulterous conduct, what would have been achieved?
Because, my lords, I'm humiliated. The petitioner has been humiliated.
So why this question I asked you almost 20 minutes back? Why you have not filed 13?
13 is pending.
So it is not helping you. Adulterous conduct, you are saying that because you are humiliated, you want to vilify your wife in public. But you will be satisfied with vengeance. Could be possibly. But I thought that it's a legal strategy. Anyway.
Oblate.
Yes.
9.
বড় হয়ে গেছে। সেটা লিখিত the learned counsel has referred to upon section 65.
65B, 4.
65B of the court submission. 65B evidence act. Indian evidence act. Corresponding লিখিত সাক্ষ্য সংহিতা। Mr. Acharya, please.
May I please? Dear my lord, I have filed one IA, my lord, 214 of 2026 flag B. Initial
Amendment prior to it is a fresh matter.
trace.
Mr. Ramdas Acharya for the petitioner, IA 73 of 2026.
Let's see.
Pardon me.
Yes, sorry.
IA
No, sorry.
21.
Section 14, Family Court Act. That may also be.
Section 14 of Family Court Act.
I've argued.
But 14, what you are arguing is not correct. Relevancy, admissibility, weight of evidence, those fundamental principles or the first principles cannot be compromised by taking recourse to 14.
That is there is a express provision.
No, সেটা আপনার ম্যাটেরিয়ালটা অলগা অর্থ আপন there is a direct decision on 14 দেখুন
2025.
ଆପଣ ଦେଖନ୍ତୁ 14 ରେ inadmissible evidence ହେଇଯିବ that will be disastrous, Mr. Pradhan. If that kind of interpretation is given by the constitutional court like this, that inadmissible evidence can also be relied upon. You see, I never realized that the court would have made a mistake. Here the court has referred to that evidence without admitting it or verifying, examining, complying with 65B.
Section 60.
Because court cannot attribute itself. Sun rises in the earth, east. Evidence darkar nahi. You'll find example. Sun sets in west. Mahanadi flows from west to east. But pen drive content, how the court can rely on the pen drive content? Under which provision?
For that matter, citing.
So that is how 65B. Supreme Court padhantu. See, we can continue. Supreme Court kala anytime it can be admitted 65 without being satisfying 65 4B. Cannot. There is no such law.
Simply, the Honorable Supreme Court said that the petitioner shall file an affidavit and that has to be.
Who stage re? Who stage re? Apna kochon na je seta sarigala pare cross examination ne kahile mu aji pen drive douch. No Supreme Court has a co-decision upon side kochon. Please give the reference. I will also read.
Right. No, akin to the present case. 2025, volume 10, SCC, page 128.
Thank you.
Vibhor Garg versus Neha.
That is also again Neha. Like Rasni versus Neha. Okay.
Heavily courts. That is a dispute on the point.
The application has been say आईएटा कितने है 2014 ये 2014 the application has been filed seeking amendment of the pleadings. The matter is at the stage of fresh admission without being considered for issuance of notice. Stop. The prayer for amendment is allowed. The IA is favored and disposed of. The consolidated amended petition shall be filed within
Within a week,
within 7 working days.
slots.
You want a date for listing?
It will be convenient.
The matter shall be listed for fresh admission in the week commencing. Upon filing of the consolidated amended petition, the matter shall be listed for fresh admission in the week commencing 10/8.
Great.
10/8.
Item number 10.
The rest of the matters after recess 10.
Bottom line.
Yes, Mr. Tripathi.
Item 39 may be disposed of. Petitioner has filed an application for withdrawal of the
That is under
amnesty.
Yes, sir.
Amnesty पाइले notice पाइले नहीं तो सेटा फाइल करियो ना मेमो रे
ମୁଁ ଦେଇଦଉଛି
ସାର୍ ଗୋଟେ କାଗଜ ଦେବେ
ଏଇଟା
Mr. ଗୋପାଳ ପ୍ରସାଦ ଜେନା
ଗୋପାଳ ପ୍ରସାଦ
ମୁଁ କଣ କହିଲି କି ସାର୍
ଗୋପାଳ କୃଷ୍ଣ ସିଂ
ନାଇଁ ନାଇଁ ମୁଁ ପ୍ରସାଦ କହିଲେ କୃଷ୍ଣ ସୁବୁଛି ନା something else ମୁଁ ପ୍ରସାଦ ପୁରା କହିଛି but check with others. Mr. Gopal Prasad Jena for the petitioner, Mr. Amarendra Prasad Ray along with Mr. N.D. Tripathi for the opposite party. The amnesty is our judgment. Order format is
WPC 31574/25.
Upon a memo agitated debate. WPC
31574/25.
The matter being in the list is the matter having been listed for hearing under the heading for admission is mentioned by the learned counsel for the petitioner as well as the learned standing counsel for the opposite party. Learned counsel for the petitioner files memo of date enclosing copy of the notice and letter.
Notice to
The letter dated so and so, issued by so and so, indicating amnesty scheme. Same order कर देबे. Computer अच्छी sufficient. Yes.
May I please your lordship?
Yes, please.
Item 10, lordship. I am through BC. Lordship, here
Yes, please.
here my prayer is lordship to reduce the maintenance amount 10,000 to 4,000.
Yes, Mr. Can you not join after recess?
Again.
Yes, please.
amount, Lordship.
No. Here I am not receiving any money on behalf of the other opposite party. The order or the direction has a purpose.
The
So
judgment.
you please look at the order dated 27/2/2026. Paragraph 6.
Learned counsel for the petition upon instruction submitted petition number 1 and 2 have not paid any amount during pendency of the proceeding or for challenging the amount before this court. So
So
he has
you want reduction by 4,000 to 6,000.
10,000 to 4,000.
10,000 to 4,000.
Lordship.
So by that, but till the matter is admitted, you have to deposit that amount.
Lordship, I deposited by way of check. Actually, money
Where?
before the register, Lordship.
No, before the trial court for the other side to receive.
Lordship, by way of money decree, but as I have already taken 2-time adjournment, so I feel that maybe case dismissed, so I filed the check rupees 30,000 some amount. That matter may be.
No, 30,000. You see, you can't alter the order.
Lordship.
Even if your senior passes away, you cannot alter the order passed by this court.
Lordship.
So the order is very simple, that you file the affidavit indicating how much you have deposited or paid or how you will secure. Obviously, you said that as per your instruction, nothing has been paid. And the judgment is from the date, the direction, including the order, from 3/9/2024. So the defaulted amount comes to BC 2,40,000 plus 6 months. 3 lakhs.
3 lakhs.
So you have to deposit 3 lakhs. So 30,000 you should not have without taking leave of the court, without an application, you should not have deposited. So don't do that. Must learn these things. It's kind of not a post office or a bank that you come here and deposit a check. There has to be an order directing to do so. So you have to think like a lawyer. The petition, Miss Susmita Misra for petitioner, opposite party blank. The learned counsel for the petitioner being present at virtual court, High Court of Orissa at Puri, addresses argument. It is submitted that by the learned counsel that she faces difficulty in contacting the client in absence of after her senior has unfortunately passed away. He further submits that she requires further time to obtain instruction in response to paragraph 6 of the order dated 27/2/2026, which was passed after hearing the learned counsel for the petitioner. Stuff. The matter shall be to grant further opportunity to the petitioner. The matter shall be listed for fresh admission in the week commencing. Yes, Mr. Maji. The week commencing 10/8/2026. And regarding whatever you have deposited, if you want to take that back or whatever, you have to file an application, petition. Correct? Yes, next.
Item number 11.
Item number 11, this RPFM, there are 2 RPFMs filed against the common judgment, your lordships.
Yes.
In 67, I am for the petitioner husband, your lordships. And on the last order, as per your last order, your lordships, we have filed the affidavit as well as.
Have you solved that copy?
Yes, on the last occasion also. Yes.
Affidavit flag B. সেটা দরকার কপি মু চাহুনি
I have not received any money.
Last order.
Judgment date কোনটো?
15/12/2025.
15/12/2025. ଆପଣ ଟିକେ ଦେଖନ୍ତୁ ଆପଣ 15/12 ରେ ଦେଲେ 20,000 ଦେଇଛନ୍ତି ତାପରେ କିଛି ଦେଇ ନାହାନ୍ତି. It has to be dismissed.
Which one, your lordships?
You are not reading your brief.
My lord, judgment is on 20/12/2025.
ହେଲା 20
ଆଜ୍ଞା।
So 20 ବାର ପରେ ଆପଣ କିଛି ଦେଇନାହାନ୍ତି
20/12 ପରେ ହଜୁର ଆମେ 75 ଆମକୁ ଅର୍ଡର କରାହେଲା ଲାଷ୍ଟ ରେ
ନାଇଁ
70
ନାଇଁ ହଜୁର କିଛି କରିନାହାନ୍ତି
70
କୋଉ
ଲାଷ୍ଟ
ହଜୁର ମାନେ ମତେ କହୁଛନ୍ତି ତ କିଛି କରିନି sir।
ଲାଷ୍ଟ ଅର୍ଡର ୟୋର ଲର୍ଡशिପ ମେସି ଲାଷ୍ଟ ଅର୍ଡର ଡେଟେଡ 25/2000
ଟିକେ ରୁହନ୍ତୁ ଲାଷ୍ଟ ଅର୍ଡର ଆପଣଙ୍କର ଟିକେ ଅର୍ଡର ଡେଟେଡ 19/3 ପଢନ୍ତୁ ଯୋଉଟା ହଜୁର କରିଛନ୍ତି ମତେ ଯଦି ହଜୁର କହୁଛନ୍ତି
19/3
ହଁ 19/3 ପଢନ୍ତୁ
yes file an affidavit
ନାଇଁ ନାଇଁ କଣ କିଛି ଫାଇଲ ଆନ୍ ଆଫିଡେଭିଟ ଏମିତି ଦିଟା ସେଣ୍ଟେନ୍ସ ଅର୍ଡର
no
read the context read para 3 6-3 ଅର୍ଡର ରେ ହେଟା actually ଅଛି
come on
20/12/25 ରେ ଅର୍ଡର ହେଲା
just a minute ah 19/3 order
ହଁ 19/3 ରେ para 3
para 3 it is again reiterated that as directed in order dated 6/3/2026 the affidavit should indicate in tabular form the details of the order directing payment of interim maintenance, details of payment made, such as date, amount, and form of payment. And
now look at the affidavit at flag B
yes, your worship.
the table. Yeah, there is no reference to any order.
There is a tabular in the page number 3, your lordship.
Yes, there is no reference to any order. By which order you have paid this, and this order is of
No,
this order is 2012-2025.
25. Here in this High Court, your lordships.
2012-2025 is not High Court order.
My lord, the
2012-2025 is the order impugned.
The impugned order is 2012-2025. Your
Kindly
lordship.
mark the last payment made.
My affidavit, your lordship, may see.
Kindly know either you have paid or not. I am not.
Yes, I have. We have paid. My lord.
Look at the table. You are not looking at me and saying Hajur कहते तापरे.
No, your lord.
अपन last date होचे 15/12. अपन 20/12
judgment hela.
तापरे अपन
We have filed the RPFM here.
अपन 20/12 order रे देबे ना देबेनी.
Yes, your lordship.
दियंतु कोई सेटा.
That is why your lordship last order has directed that 75,000 to be paid as well as 15,000 as a interim maintenance. That is we are complying today, your lordship.
ଆପଣଙ୍କର ଏରିୟର କେତେ ହେଲାଣି?
ଏରିଆରେ ଆଜ୍ଞା କହିଥିଲୁ ପରା ଟୋଟାଲ ହଉଛି ଲକ୍ଷେ କେତେ ଟଙ୍କା ଜମା ଏରିଆରେ ଆମର ହଉଛି ସେତେବେଳେ ଆମେ ଦେଖେଇଥିଲୁ your lordship.
para 6 ଟା ପଢନ୍ତୁ.
para 6 of my
ହଜୁର କହୁଛନ୍ତି କିଛି ପଢନ୍ତୁ.
No, your lordship. para
6 ଟା ପଢନ୍ତୁ ଅର୍ଡର.
para 6 of
ଲାଷ୍ଟ ଅର୍ଡର ନିଜେ କହୁଛନ୍ତି ଫେର କହୁଛନ୍ତି para 6 of.
para 6 of it is submitted by the learned counsel for the petitioner that the application seeking maintenance 125 CRPC was filed by the wife in marriage on 30/9/2022. It was disposed of by judgment dated 20/12/2025. Prior to disposal of 20/12/2005, there was an interim direction for payment of maintenance. Referring to the table annexed to the affidavit as well as supported by affidavit, he submits that this starting with 2/3/2023 up to 15/12/2025, 6,60,000 has been paid.
So that was the reason. The order is that with reference to which order you have paid, that you could have mentioned, which you have not mentioned.
My lord,
In the table, you have completely left that column. In fact, you have not added that column.
my lord, affidavit I have indicated, your lord.
The table.
Which
ଆପଣ affidavit 5 ଥର କହିବେ ମୁଁ 5 ଥର table କହିବି. So why does it lead?
table is just separately, my lord. I have
Separately କେମିତି ହବ ଆଜ୍ଞା? ମୁଁ କେମିତି ଜାଣିବି?
there are since
ଆପଣ
the
ସେଇ
duties,
ଯୋଉ ବର୍ତ୍ତମାନ ବି ଲେଖି ପାରିବେ ଆପଣ ଯୋଉଟା amount ଦେଇଛନ୍ତି କୋଉ order ହେଲା ଆପଣ deposit କଲେ. Now also you can read it.
I have
Now
mentioned.
kindly read para 7.
Your lordship may see my affidavit for a moment.
Look, I will not read.
Yes, yes,
order.
yes, yes.
Kindly don't
My lord.
waste time. Read para 7. You have stopped reading after 6.
Para 7, your lordship. Para 7, it is directed petitioner shall deposit the arrear from month of January 2026 to May 2026 at the rate of 15,000 per month, that is 75,000 without prejudice to his right and contention in the present petition, and he shall continue to pay the amount of 15,000 per month during the pendency of this petition without prejudice to his right and contention. the wife in the marriage shall continue to receive the amount without prejudice to her rights and contention in the present petition as well as RPFM 94 of 2026. This is the order which
The problem is that now you are yourself not sure that 6,60,000 you was paid to by which direction?
yes, your lordship, that is the direction.
So kindly look at the table again.
My lord,
My
table,
lord,
table of my affidavit.
a coup table.
Yes, your lordship.
The table on
Para,
which you are standing on one. How is it relevant? At times it sounds so funny.
my lord,
table para 3 re
para 5, your lordship may see, para 5. During the ad,
table le para 5 nahi khali table achi.
table is just separately, my lord. I have,
So separately सेटा कोन माने पचाले खराब ना कोन सेटा एते किछ खराब भी नो
No, no,
आपण अनंत किछ असुविधा हबन
my lord,
बहुत भलो टेबल सेटा
table,
table.
table starting from,
आपणकर जो 2 मार्च 23 रे देले
आज्ञा,
माने ऑर्डर हेतिला गोटे ऑर्डर हेतु एंट्री मॉडल
Yes.
तो सेटा को आपण बाम पटे ता लिखि देबे
oh, my lord.
एबे भी लिखि परिबे
Alpha.
तो सेटा हेतिले कोन हे थांता जे आपणकर एफिडेविट इज आई डोंट रिक्वायर एनी एफिडेविट टू कंसीडर आल्सो आपण तो कहउचन दिचंती से देखिबे वेरीफाई करिवे मिस्टर वर्मा जे पाइचंती कि नहीं I understand but the problem is suppose I'll suppose now let us assume I will say in your favor that pursuant to this order this amount has been paid that order is not there आपण को आपण para 5 आपण para किते को आपण पसंद को paraटा कहउचंती एफिडेविट रे
Entire affidavit shows, but para 5 is
सोर्स कथा नहीं
para 6, your lordship. Para 5.
ता जदी लिखिले सेटा कोन टेबल रे रहि पर न थांता सो दैट सी भी
Yes,
ट्रांसफर करे सुविधा है थांता बर्तन से कहेगा देई नांती से जो कहउचन मो କିଛି पाइनी this is usual start
It is,
by the way
it is all,
now court is in a quandary that आपण को ऑर्डर रे केते टंका देले सेही जिंसटा गोटे सिंपलीफाई हे पर थांता
No, they cannot-
it is not against you actually. It is in favor of both of you.
but we have paid all the amount to DD, your
Just
lordship.
one second. Mr. Verma, you have, I mean, check with your client these payments.
I have checked my lord. I was instructed that he has got 6,40,000 rupees.
20,000 तफातु.
20,000.
रखा है. ताला आपको clear not.
Till date, my lord, there
ठीक
is
अछि. So
11.
now he is filing this 70 as directed. 75 ପରେ ବି ସେ 15 जो Mark Mr. Bhanti has not said that you will not pay. So ଆପଣଙ୍କର now what is the issue remains now?
1 minute. Till date, my lord, as per the order, previous order, my lord, there is 11.5 months amount, maintenance amount is pending. That is
From the date of payment.
From the date of order, my lord.
No, date of payment. Sorry, date of application. I'm so sorry.
From the date of application, yes, my lord. From the date of application, my lord.
My lord, the order judgment was passed on 2012-2025. Now your lordship has directed as per
3922 3922 ରେ
39-22
30 9 20 22 ରୁ ଆପଣଙ୍କର
30/4/26 ଯାଏ
6 lakhs 6 ଆପଣଙ୍କର ଯୋଉଟା ପେଣ୍ଡିଂ ଅଛି ସେଟା ଥାଉ your point is well taken he is not disputing ତାର ଆଉ ଗୋଟେ reason ହଉଛି କଣ କହିଲେ he has himself damaged his table ଯଦି ସେ ସେଟା କହିଥାନ୍ତେ I would have asked you but he has not done so I cannot ask him so we now suppose from 392022 just look at that table again.
I started paying from
So
2nd of March.
2 ମାର୍ଚ୍ଚ 23 ରୁ 30 9 22 ରୁ ଆପଣଙ୍କର ମାର୍ଚ୍ଚ ଯାଏ ହଉଛି 6 ମାସ 9 10 11 12 ଏପଟେ
ये 6 मास ये 5 मास
6 ମାସ ଏ 5 ମାସ
ये 6 मास ହେଇଗଲାଣି ଏବେ 6 ଜୁନ
ସେ ବର୍ତ୍ତମାନ ଦଉଛନ୍ତି ସେ ବର୍ତ୍ତମାନ ଆଣିଛନ୍ତି ସେ ଆପଣ ସେଟା ଛାଡୁ ଦେଖୁନାହାନ୍ତି
here my
ଆପଣ ଏମିତି ଦେଖୁଛନ୍ତି
75 plus 15 we are paying. So far as 15 is
just give me a second I'll just sign this. Your concern has been, I think,
No,
I mean, may not be adequately, but at least very reasonably taken care of. At least this is a litigant who is not defined. She has paid from the 9 22 ଧରିଲେ ବି ମାର୍ଚ୍ଚ ରେ ସେ ଦେଇଛନ୍ତି ଏଇ ଯୋଉ ଆମାଉଣ୍ଟ ଗୁଡାକ ଯଦି ଆପଣ 15,000 ରେ ଦେଇଛନ୍ତି ବୋଲି ଆପଣ ରିସିଭ୍ କରିଛନ୍ତି ଦେଖିବା ରେଷ୍ଟ ଆମାଉଣ୍ଟ ଦେଖିବା ବଟ୍ ଆଇ ରିକ୍ୱେଷ୍ଟ ବୋଥ୍ ଅଫ୍ ୟୁ ଟୁ ୟୁଜ୍ ୟୋର ଗୁଡ୍ ଅଫିସର୍ସ ଟୁ arrive at a settlement. The reason being you are more you will be more what you call at least your client will listen to you because the amount has been paid. Correct. So you find out ଆପଣଙ୍କର submission କଣ Mr. Mahanti କେତେ ଦେବାକୁ ଚାହୁଁଛନ୍ତି?
My lord, outrightly 25 lakhs because the divorce is also pending. 25 lakhs is a
ଆପଣ 13B ନା 13(1)?
13(1), your lordship. Not 13B. We have
13B ଗୋଟେ file କରନ୍ତୁ.
we have consistently tried. I have requested my learned senior time and again. He is asking
May make a small submission.
Yes, please. Then
living separately for one moment, for 2 lines, your lordship. Both the parties are living for after 1 year of marriage. They are living since 2019. They are living separately. Only they are contesting the cases as only for contesting the my lord.
They have to.
Yes, your lordship.
They have to for both of you and for this court.
So now both
How the lawyers. So what the lawyers will do if the parties agree for settlement and settle among themselves, both of you. The big office Mr. Verma runs and this court establishes.
I always for the settlement.
Since I am not paying it, your lordship, and he is in receiving, so he has to.
They are. You are not doing any charity. You have to maintain.
Yes, your lordship.
At least in your case, you have a good person who is listening to you. Otherwise,
Yes,
the usual say brief. The brief has been
May I
transferred.
have a small submission, my lord?
Yes.
My lord, in the entire petition, my lord, they have suppressed the fact. My lord, nowhere they have written that the petitioner there in their case.
So, Mr. Verma,
My lord.
my effort when I said that when I started requesting both of you to arrive at, I was not going into the merits. So you might have a very good case, but the ବର୍ତ୍ତମାନ ଯୋଉ situation ଆପଣ ମାନଙ୍କର ଭିତରେ both the parties ଙ୍କ ଭିତରେ ଯାହା ହେଲାଣି, so at least you have now maintenance. This court has ensured continuance of maintenance. So in that scenario, you are in a position to explain your client that at least the litigation is not leading to nowhere. Litigation is leading to nowhere as far as the marital life is concerned. ଆପଣ 13(1) କୁ 13B ବି କରିପାରିବେ, but ସେଇଟା ଆପଣ ମାନଙ୍କ ବହୁତ endeavor ଦରକାର. Many a times you will find that after 13(1) is allowed or disallowed, then at the stage of appeal they are saying that yes, we are agreeing for 13B.
This can be sorted out within a very short period. But the thing is that the husband is earning more than 7 lakhs and he has not given the affidavit or any document.
ଆପଣଙ୍କର 25 lakhs ରେ ଆପଣ ସେଟାକୁ 30 lakhs କି 50 lakhs କହିବେ ସେଟା ମୁଁ ଜାଣିନି. I am only on the 125. 125 ରେ ଆପଣଙ୍କର you will succeed, but whatever Mr. Mahanti may succeed. But that is one aspect of it. But the broader aspect is that if you can work out a solution, please go ahead with that.
Yes,
125, Mr. Mahanti has said that he fairly states that both of are litigating.
But the amount is the difference amount is very much better. 7 lakh, but they are showing.
You discuss with your client.
We have already, both of us has already discussed.
say ଆପଣଙ୍କର ଆପଣ ଯଦି କିଛି ମ୍ୟାଟେରିଆଲ ଅଛି ବି ଦେଖେଇ ପାରିବେ ଯେ ତାଙ୍କର ଇନକମ୍ ଏତେ 7 ଲାଖ ଟଙ୍କା ସେ ଏତିକି ଟଙ୍କା ଦେଲେ ହବନି, କୁହନ୍ତୁ ଦେଖନ୍ତୁ କଣ ହଉଛି. Let us see.
The problem is that we don't have any document because he is working in Netherlands. He is working in Netherlands and he has not submitted a single document regarding his bank statements or income tax before the trial court. He allowed it to be proceeded ex parte so that he don't have to face the trial. So all those things happen. So if he can come up with some reasonable amount.
13 ଟା କିଏ ଫାଇଲ କରିଛନ୍ତି ଆପଣ ନା?
13 I have filed. Thereafter, in response to 13, they have filed this 125 domestic and all other litigations.
If he is down, obviously.
And so far as my learning,
କରିଥାନ୍ତେ
my lord,
କଣ କରିଥାନ୍ତେ? କନସିଡ୍ କରିଯାଇଥାନ୍ତେ ନା କଣ? WS ଲେଖିଥାନ୍ତେ let the 13(1) be allowed without any.
From the day, because since there is no question of resume of their marital relationship due to several factors, your lordship, this is the only logical end for which the husband can file. Otherwise, he cannot file any other than 13(1).
চেষ্টা করুন at least to your satisfaction that you are receiving the interim maintenance. You may not be happy with the amount, but at least they are depositing the amount. I'm sorry,
yes.
While
maybe if HLM amount maybe increased to a little bit, so it will be convenient.
ଶୁଣନ୍ତୁ, bird in hand is better than two in the goose. So ଆପଣଙ୍କର maintenance has been ensured. So ଆପଣଙ୍କର ବର୍ତ୍ତମାନ କଥାବାର୍ତ୍ତା କରନ୍ତୁ. Yes.
both are at their young age, they can,
They
they can
should
move on.
decide
Lordship.
their individual life.
They can move on because there is no point of fighting after 5 years of separation.
Medicines.
And only for sake of only maintenance. This
Maintenance से mediation ର scope ନାହିଁ ଆପଣ ଯଦି
mediation they have already
13 conciliation ପାଇଁ ଯଦି କରିବେ ଆପଣଙ୍କର ଏଥିରେ move କରନ୍ତୁ family court
my lord in all
professional counseling by the counselor is different than a mediation ଏଥିରେ mediation କଣ mediator କଣ କହିବେ
mediation, consistent mediation has been taken place in all the in the divorce case 125.
Still repeated mediation can also help. In some land acquisition matter, I have found that second, third time they are agreeing. When there is a apportionment, they are denying initially, but then they say that yes, we will agree that way. So that way you have to make an effort.
My learned senior will agree, my lord, except the quantum. There is nothing to decide so far as the even my learned senior after obtaining instruction he can find.
That is the reason, Mr. Mohanty, that why you are not approaching the court by 13B.
My lord, 13B, unless he will agree, they will agree because that is the proposal. I am consistent.
You cannot say he will agree. Both the parties should agree.
Yes, yes.
He and C,
yes,
he
yes.
and C agree. Then
I'm, my lord, beg apology, but that is the thing, my lord. Unless both the parties will agree, my lord.
Mr. Pradipta,
I'm filing the
second time enhancement ପାଇଁ
No, my lord.
ଆପଣଙ୍କର enhancement ପାଇଁ ତ
When the admission, it has not yet been
their
admitted.
matter has not been admitted. 94.
67 ଟାରେ ଦେଖିବା 67 ବି admit ହେଇନି
67 admitted on which they are receiving the money right now.
Admission ହେଇନି.
ନା ହେଇନି 1 2 No, it has not been admitted. Se appear করଛନ୍ତି अपन আরটারে
67.
The Lord Counsel for the petitioner, you received that draft. You will receive of the petitioner.
I will receive it. I will receive it.
Yes, sir. The copy ଅଛି ତା ଦିଅ
Yes,
ତ କରିବାକୁ ପଡିବ ଆପଣ ଏଠି ପାଇଁ ମେସିନ୍ ଅଛି
yes. Copy xerox.
ପୁରା ଏଇଟାକୁ ଗୋଟେ ଏଇଟାର ଆର ଗୋଟେ ଫଟୋ ଏଇଟା ପୁରାଟା କରିବେ ଏଠି ଆପଣଙ୍କ ମେସିନ୍ ନାହିଁ କରି ନେଇ ଆସ ସେଟା ଦିଅ ସେଟା ଆର କପି ବୋଧେ ଠିକ ଅଛି 57 लिखो Mr. Vivu Prasad Mohanty for the petitioner, Mr. Pradipta Verma for the opposite party. The learned counsel for the petitioner as well as the learned counsel for the opposite party were had at some length. The learned counsel refers to the order dated for the petitioner refers to the order dated 19/3/2026. Wherein at paragraph 3, the following direction was issued. He submits that affidavit has been filed on behalf of Nijay Chandanpati.
Yes.
Chandanpati Huchanti.
Husband.
On behalf of the petitioner, enclosing at paragraph 3 or indicating at page 3. Enclosing at page 3, a table indicating the date of issuance of demand draft and the amount paid. The table also indicates the demand draft number. Though the table does not indicate the order pursuant to which such deposits, such drafts were made and handed over to the opposite party wife in the marriage, it is submitted. It is indicated that payments were made with effect from 2 March 2023 up to 15/12/2025. The learned counsel for the petitioner Hands up. Demand draft. Number so and so, dated so and so, drawn on Union Bank of India, payable at Baleshwar main branch in favor of the opposite party wife. Both the drafts are filed along with a memo. The photocopy along with a memo stuff. The drafts are received by the laureate counsel for the opposite party wife in the marriage. The laureate counsel for the opposite party has put his endorsement indicating the receipt. The photocopy of the memo. Original रखी ताकू देबे
Xerox to दे दीजिए. Yes, yes.
ये कि तो आको बार कुछ होइबो
I'll take a print photo.
आउ गोटे दुईटा मु एक्चुअली गोटे कहली आउ गोटे the original memo along with indicating endorsement of the laureate counsel for the opposite party receiving the draft, receiving both the drafts plural for a total amount kete
90,000.
amount for an amount of rupees 90,000. जो ड्राफ्ट डिटेल से अमाउंट हम छाड़ दीजिए अमाउंट पॉकेट अमाउंट टैक्स नंबर एते डेट एते अमाउंट एते ड्रॉन ऑन यूनियन बैंक ऑफ और सेंटेंस पड़ता he receiving the memo in original along with the endorsement is kept on record along with photocopies of the drafts. The copy of the memo is also handed over to the laureate counsel for the petitioner as well as the laureate counsel for the opposite party. It is submitted by the laureate counsel for the opposite party that the petitioner's the petitioner husband in the present application has not disclosed his income before the laureate judge family court. He was sent ex parte. He preferred to prefer not to appear in the matter any further. The amount of rupees, like kitna direction is
20,000.
the amount of rupees 20,000 is not commensurate with the income earned by the opposite by the petitioner husband, and accordingly, the RPFM 94 of 2026, which is tagged together, has been filed, which is tagged with the present case, has been filed for enhancement. It is submitted that the maintenance for 11 months remains unpaid from the date of making of the application, that is
Now it will be 5 months because they paid like 6 months.
was remaining unpaid with effect from the date of filing of the application, that is the receipt of IC. Stop. It is stated by the laureate counsel for the appearing parties that the parties are also litigating, as the petitioner husband has filed application seeking divorce, seeking grant of divorce under under section 13(1) of the Hindu Marriage Act, which is pending before the laureate judge family court, Bhubaneswar. The laureate counsels for the parties are requested to make all endeavors to arrive at a settlement acceptable to both the parties. As it is stated by both the petitioner as well as the opposite party that they have been separated since
2019.
2019. The matter shall be listed for orders in the week commencing 3/8, 10/8, 10/8, 10/8, ଆପଣ ଗୋଟେ ଅର୍ଡର ସିଟ୍ କରିଦେଲେ କି ହଁ ମାନେ ଗୋଟେ କଷ୍ଟ ଆକ୍ଟରେ ଲେଖିକି
Your Lordship, only one submission so far as my learned seniors observe, say, submission is concerned. Petitioner never been set ex parte. First, so far as the my lord petitioner has participated, filed his assets liability, both.
set expert line what
Yes, Your Lordship. The question of set expert is not there. Yes.
ସେଟା ତାଙ୍କର submission actually ମୁଁ
Yes, yes, yes. But only since it
in
will
fact
be
that is not an observation of the court, it is a submission of the learned counsel.
never
That
been
is
a
very
set
clear.
ex parte.
See like the what
Yes, yes.
expert like that.
Right.
Item number 12.
ଏଇଟା
Item number 12.
ଏଇଟା ପୋଷ୍ଟିଂ କରିଦିଅନ୍ତୁ ତ ପାସୱାର୍ଡ ସରିବ ସେ ଅର୍ଡର ସେ ଗୋଟେ କୋଉ ଦିନ ରଖିଦିଅନ୍ତୁ
Item number 13.
ଚେକ୍ କର
One BC from Kalanti Virtual Hack Mallots.
Item number 14.
Vivekananda Jena for the petitioner.
Mallots item 13.
See, actually,
Virtual High Court Kalanti Mallots. Mallots. Petitioner is the
yes, please.
Petitioner is the white ballots seeking transfer of CP number 97625 from Learned Katak, Family Court Katak to Bhavani Patna Mallots.
Yes.
In Bhavani Patna, she already filed a 13IA of dissolving of marriage Mallots.
9 is filed at Cuttack.
9 is filed in Katak by husband.
You are for the wife.
Yes, Mallots.
Wife has filed 13.
13(1)A.
Okay. Mr. Ankan Panda for the petitioner. Take notice.
Mallots.
The Lorded Counsel for the petitioner being present at the virtual court, High Court of Orissa at Kalahandi, Bhavani Patna at Kalahandi.
Bhavani Patna, Kalahandi.
At Bhavani Patna, Kalahandi addresses arguments. The petitioner before this court is the wife in the marriage. She seeks transfer of the CP number 976 of 2026.
2025.
2025.
25.
CP C.P. number 976 of 2025. The said CP stops. The said CP has been filed by the husband in the marriage. Sentence after product. She seeks the transfer of. Stop. Comma. Pending before the learned judge, Family Court, Cuttack, to the learned judge, Family Court, Kalahandi at Bhavani Patna. Then full stop. The said CP pending before the learned court at learned Family Court, Cuttack, had been filed by the husband in the marriage under Section 9 of the Hindu Marriage Act, seeking restitution of conjugal rights. It is submitted by the learned counsel for the petitioner that the wife in the marriage has filed a CP number 86 of 2025 under section 13 into bracket I-A, Roman 1-A into bracket closed of Hindu Marriage Act, seeking dissolution of the marriage solemnized between the parties on 5/7/2023. Which is pending adjudication. The body is sitting on the window, listening to the court proceeding. It's a parrot actually. No, never. Let him learn some legal language also. Rajnish versus Neha. In fact, a parrot should sit and listen to the lawyers also. I mean, the parrot will think that I can't match. Yes, the repetitiveness of. Yes, next.
14.
Panic.
Yeah.
That's dictation. Mostly I am listening to the parrot, if I could understand anything. Many times I get confused whether I am listening to parrot or a human being. It's not it, by the repetitive submissions. Yeah. Seeking dissolution of the marriage, parties solemnized on pending adjudication. It is submitted that the wife is maintained, Mr. Panda.
No, my lord.
Or she has filed again maintenance.
No, my lord. She has not filed entry.
Okay. It is submitted that in the interest of justice and in the fitness of things, both the applications under section 13(1) into bracket 1A IA and the application under section 9 of Hindu Marriage Act should be taken up together. Para. They submitted that the wife finds it difficult to attend the matter at Cuttack. CCTV on chakiri karchhanti na rahuchundi.
No, my lord. She is living in parental home, my lord.
As she lives in her parental home at Bhawanipatna.
Kissinga, my lord.
Kissinga.
Masani
Kissinga in the district of Kalahandi. After her marriage has run into rough weather. Has ran into rough weather. Stop. Issue notice to the opposite party along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. Returnable date be fixed to? Haji Sahab? 3/8 listed on 10/8 रो returnable date be fixed to 3/8/2026 ଆପଣ କହୁଛନ୍ତି ମାସେ ହେବ 10/8 ନାଇଁ କି fixed to 10/8/2026 the matter shall be listed for orders in the week commencing 17/8/2026.
14.
In the interim, it is directed the proceeding before the learned judge family, the CP number pending before so and so Cuttack, and the CP number pending before the so and so Kalahandi Bhawanipatna shall be adjourned to a date beyond 24/8/2026 as would be convenient to the learned court in season of the matter, learned courts in season of the matter, upon a prayer being made for the state purpose.
Much obliged, my lords.
Yes, please. 14, Mr. Jenna.
14.
The petitioner, your lordship, is challenging the order under Annexure 3 series, your lordship, where a compromise has been entered into in the National Lok Adalat by the opposite parties without making him a party, though he is a co-partner in the same. From the daughter's side, your lordship, may kindly see the genealogy they have provided in their plant at page 21.
Yes, 21.
Genealogy is Narayan Ponda, who have 2 sons, Parsuram and Gangadhar. Thereafter, Parsuram has 4 sons, but actually Parsuram has 4 sons and 1 daughter.
Okay.
They have not made the daughter as a party, although she was dead, but now the present petitioner is the son of the that daughter. And your lordship may kindly see Annexure 5 series, 6 series, your lordship, page 58. That is the school leaving certificate.
No, actually, that this court did not look.
Yes, your lordship.
So you have filed IF for seeking leave.
IF.
You have to file application to seek leave for appeal, leave to appeal. On the party no thile na.
No, party no thile.
So file that IA. How much time?
1 week. And
One
another
week.
thing, now they have filed another suit where they have made me a party for partition of the.
No, in the civil suit where you are not a party.
No.
There is a compromise decree, order and decree that you are challenging.
Which was compromised before the National Lok Adalat.
Correct. So
And
that you have to challenge in a writ petition.
Yes.
For that you have to seek leave.
I will file IAS.
Hard learned counsel for the petitioner, Mr. Vivekananda Jena, for the petitioner. It is submitted by the learned counsel for the petitioner that petitioner, though was supposed to be a proper and necessary party in the civil suit, CS number 900/1175 of 2022, which was disposed of in the Lok Adalat, the National Lok Adalat, by the learned civil judge into bracket senior division Balasore. ଆପଣଙ୍କର order of decree date ଟା ହେଉଛି by order dated 3/8/2022 and final decree was drawn on.
Final decree was drawn on.
Date ଟା ହେଉଛି the decree shall bear the date of the judgment actually ଭିତରେ କହିଲେ କଣ sentence ଟା ପଢନ୍ତୁ. CPC provision ହେଉଛି the decree shall bear the date of the.
Yes.
କଣ sentence ଟା ପଢନ୍ତୁ last. And final decree has been done, full stop. It is submitted that the petitioner shall file application seeking leave to appeal.
Decree dated
And the matter may be adjourned.
25/8/22.
Should I quote by little?
That I have stated in my written statement.
Acha.
Page 49, Your Lordships.
But I think as per CPC, it has to be the same date.
Same, but final decree was drawn.
Final decree, the decree shall bear the date of the judgment. अपन देखिए वैसे अच्छी provision.
But in fact, the decree is dated 13th, the day of judgment, Your Lordship.
You have copy?
Decree copy.
नहीं, CPC टा करो. CPC टा दो. All right. Boros. Thank you. Order 20, Rule 7. Double X. Double X is 20.
Lordship, date of decree. The decree shall bear date the day on which the judgment was pronounced, and when the judge has satisfied himself that the decree has been drawn up in accordance with the judgment, he shall sign the decree.
The decree is dated the day same as judgment, but the judge will sign after satisfaction. There can't be two dates on a decree. Okay, decree has been done. Shall file application seeking leave to appeal. The matter may be adjourned. To grant up the matter shall be listed for orders in the week commencing.
Next week.
Next week as well. No. It shall be listed in the recommencing 20 to enable the petitioner to file the appropriate application.
Item number 15.
Item 15. May I please, Lordship?
Yes, please. Mr. Sandeep Raj Panda for the petitioner. Opposite party flag. Yes, Mr. Panda.
Lordship. In this writ application, I am challenging the order dated 19/2/2026 under Annexure 3 of the Family Court Cuttack, my lord. Here the petitioner is the husband and the opposite party is the wife, my lord.
Yes.
I'm filed one application praying that kindly allow me through virtual mode as and when required in the court, my lord, because I am for my educational commitment, I am staying at Newark in USA, my lord. Now the difficulty is that once he came to India for the purpose of his recording of his evidence, his H-1B visa may be impact, my lord. That's why my humble submission before
adjournment nebe ko kari. Adjournment niyantu.
Adjournment do na. Today is the date fixed for evidence of the.
Kali Trump sahab kon kohibe kahiyoboni. H-1B visa is now.
My lord, that is in danger, my lord.
Danger katha nahi. H-1B visa in process we upon client pacharibe. I mean, law firms are like Fragment Del Roy and all that. They are earning a lot out of it. ଆପଣଙ୍କର ଗୋଟେ କମ୍ପାନୀରେ ସେମାନେ ଯଦି H-1B visa କଲେ ତ full time ତାଙ୍କର କାମ ହେଲା H-1B visa ତିଆରି କରିବା.
That is costly, my lord.
So now he has imposed a fees. That fees, I think, is struck down by Supreme Court or some federal court.
Today is the date fixed for the evidence recording of evidence of
Adjournment
the
new.
wife, my lord.
Adjournment new.
My lord.
But the order ta पढ़िले जोटा input order ta देखो college. Try to always be pinpoint in your approach as far as dispute order is concerned. That should make a mark. ଆପଣ କୋଉ part ରେ କଣ କହୁଛନ୍ତି ସେଟା just find it out.
My lord. And page 39, lordship.
Yes, I am there. 40. Not 39, 40.
40. Can I read the
After
relevant?
to video conferencing ତାପରେ ପଢନ୍ତୁ କଣ logic କଣ ଆପଣଙ୍କ submission ଥିଲା. On the other hand, the petitioner object.
Third para, my lord.
नहीं पुराटा पढ़ନ୍ତୁ. On
Mile.
the other hand, the petitioner.
The case record is put up today for the order on petition dated 18/3/2025. After pendency of 1 year, the application was disposed of, my lord.
ଏଇଟା ପଢନ୍ତୁ ଆଗକୁ ଦେଖିବା. Let us concentrate on this. On the other hand, the petitioner objected the petition and stated that 40 ରେ सब पारा ଦେଖନ୍ତୁ.
On the other hand, the petitioner objected the petition and stated that the petition is not maintainable, and in the meantime, the conciliation is failed as the respondent has not appeared before the conciliation settlement. The respondent has already filed show cause, and the petitioner has already filed evidence affidavit to process with the case. The permission
proceed with the
case. The permission to appear through video conferencing by the respondent is out of the imagination because he is out of the country where there is no facility for video conferencing. Therefore, she prayed for dismissal of the petition being devoid of merit. I have already heard both the parties at length, pursue the case record and connected material available with it. On perusal of the case record, it reveals that the respondent has filed his objection and the petitioner has also filed her evidence affidavit before this court. Though the respondent filed the petition seeking his appearance through video conferencing from outside of the country, but he has not specifically mentioned about the country name and place of his stay details. That apart, he has specifically made a prayer. Next page, madam. To appear in the conciliation through video conferencing. In the meantime, counseling report received by the court with a remark that the respondent did not appear on the date fixed for counseling and not made any prayer before the counselor to appear through video conferencing. So filing of this petition without any authentic particular is not sufficient to allow him to appear through video conferencing without any specific address, remote point and coordinator engaged therein, the specific reason for his non-appearance. Hence, the petition deserves no positive consideration. As such, the same stands rejected.
How can you fault this order, Mr. Ponda? This is as per the rules.
My lord.
In video conference also, because video conference has the risk of being sabotaged, hijacked and somebody else may appearing. There can be so many pilferage, you can say. Possibility of I mean, in the process,
Maybe tampering, maybe AI impact.
it can be compromised. So that is how the remote point coordinator engaged, because that is how they identify. Every day when you look at the news, you will find that AI generated video. Every litigation, every crime is reported in as if happening in reality. So simply you have to give a command to AI.
I made a small prayer, my lord.
Actually, there is no error apparent or no error absolutely in the order.
If possible, he appeared through Indian embassy, my lord, because
that I do not know. If Indian embassy can be utilized, we have to check the rules. Whenever you are coming to the court with a proposition, you have to complete grasp over the video conferencing rules. We are having that.
If I made
without reading that, you cannot assist the court.
If I will made a party to Union of India, my lord.
Because your points are valid. If he comes to India, his H1B will be cancelled. Once H1B is cancelled, then he cannot return back. Then he loses his job, everything. The only thing is that if you seek adjournment, I don't find anything wrong actually. The court has not given any finding against you. Rather has simply reproduced the facts as you have said. And they thought that it's kind of a Zoom meeting like we are having. It is not video conferencing. It's a platform. Anyone can appear. That you will find that this after it was misutilized, we have developed this waiting room also, because everyone entering has a problem, and they are also even his version has to be recorded. Now, suppose your client comes up and says that I never appeared, I do not know what happened. Then the court is at its wit's end to answer that. What setting adjournment nahi the hard apparent the learned counsel for the petitioner is had at some length. The petitioner is the opposite party in the CP number 632 of 2024. Pending adjudication before the learned judge, Family Court, Cuttack. The present application is filed challenging the order dated 19/2/2026. Rejecting the petition filed by the present petitioner, who is the opposite party in the CP. CP number in the CP. Seeking appearance through video conferencing. Which has been rejected. The CP has been filed by the wife in the marriage under section 13(1) IA, Roman 1A, A, seeking a dissolution of marriage between the parties and grant of decree of divorce. To reject the prayer of the present petitioner as opposite party before the learned the opposite party, the learned judge, Family Court, has given the following reasons. Court I have already heard page 40 up to stands rejected. It is submitted that the petitioner is facing immense difficulty to appear as he works in USA, the United States of America.
Study.
As study congregation be. Say he's not relying on you, he's misguiding you. Student visa is different. H1B is limited to
IT professions.
The study केमती हो? This is the problem, Mr. Honda. When you start, you have to tell the court. When the court starts dictating, it becomes actually a hopeless situation. My entire logic goes haywire. कौन लिखले? आपण से पढुचोते ना काम करूचो?
पढ़ुଛନ୍ତି ତ मेरे स्टडी एंड ହେଲା 3 मंथ ତାଙ୍କୁ ग्रेस पीरियड ଗୋଟେ ମିଳୁଛି सर्चिंग ऑफ ए जॉब माय लॉर्ड After that, if he failed to search any job, then return back to their own country.
So say student visa extension थियो student visa exact मोर नाटा मने पडुनी मु भूली गले देखिले most likely F1 anyway sir अपन तो जानि नांती आपको कॉल करी कॉल लेके as he studies in USA has a student visa which is to be extended till he gets a job and he has to look for a job during the said period after his studies are over. He cannot travel to India to attend the matter at Cuttack as his study and search of job at USA would be impacted. Para. The submissions and the facts stated by the learned counsel for the petitioner appears to be correct and which are and which have an impact on the petitioner appearing before the learned judge family court Cuttack. Stop. However, comma. The reasons given by the learned judge family court are just and proper. The reasons given by the learned judge family court in order dated 19.02.2026 in rejecting the petition dated 18.3.2025 prima facie appear to be just and proper. In such scenario, is directed that the CP number so and so, pending report so and so shall be adjourned. But कितने दिन time ले सुविधा हो so that you can have something to, because you are in a fix actually, you are neither here nor there. आपन के सुविधा कोन कले फ्रॉम सब आपन को पूरा कहि पळा गले ताले आपन इति आसिले केस फास कले ये कले पाठ पढिले चाकरी कले जा करिवे मतलब सेठी जे रोजन तार अवस्था ला एटा को दिन के सकाळ होजन आज घर पळा. This has happened actually. They will enter the university कहबे तमन सरी गला काल तो पळा. That becomes a problem.
Job रे पंचिंग काम करने next day.
तो जा भी हो सेटा भी चैलेंज करूछन. They are the lawyers have to rise to the occasion. The citizenship by birth, it has been it was amended by it was directed by the executive instruction and the Supreme Court has struck it down. It continues. So
green card.
I mean, in a democratic country like India or USA, the oldest democracy, they are celebrating 250 years. The role of the courts are much more important. ଆପଣ ଏବେ କିଛି ଦିନ ଯାଇ ପ୍ରାକ୍ଟିସ କରୁନାହାନ୍ତି. You also argue the cancellation of visa, extension of visa. Beyond କେତେ ହେଲା 9 ତାରିଖ beyond କରିଦିଅନ୍ତୁ 17/8/2026 as would be convenient to the learned court in season of the matter. Upon a prayer being made for the said purpose, the present petition shall be listed for orders in the week commencing 10/8/2026. But their bar examination is very tough. Very tough bar examination.
English paper is short.
So that way it will help you. Once you prepare for that, you prepare for your practice also. Yes, that is a parallel issue altogether. Yes.
16.
Apanakara said just other parties that you have to verify in our rules how this suppose a person is located in another country, what can be
Their
done?
remedies.
What can be done? He can appear. What you're saying, I was thinking that actually, that he can be identified and appear in the Indian embassy if it can be arranged. Yes, next please.
Let me.
16. My lord, in this case, my lord, petitioner.
Mr. Sapan Kumar Pal for the petitioner.
But I am appearing. But I am appearing
Opposite party.
for the opposite party, my lord, not in the contempt application, but in the connected writ petition, my lord. I've got instruction to appear in the connected writ petition. The contempt petition has been filed. It has been tagged up with this case, my lord.
This is within the determination of this bench.
No, my lord. So far as contempt jurisdiction is concerned, probably that's the reason why the contempt matter has come before your lordship. But so far as the writ petition is concerned, it's the assignment of court number 1, old building, my lord.
Yes.
No, I don't have a contempt jurisdiction separately.
Yes.
After honorable court order, they terminate my service, my lord. Honorable court, in interim measure, honorable court specifically stated that it is directed that any action taken in pursuant to the annexure 2 and 3 shall be abided by further order of the court.
Your contempt has to be dismissed, Mr. Pal.
My lord.
Your contempt application has to be, there is no contempt. So you can always challenge. You can always challenge that any action taken means you can challenge that action, whatever they have done. But contempt court will.
Well, then also abide with the result of the writ petition.
No, it will.
Yes.
It can be undone on the same ground that whatever you are arguing now,
Yes.
if your prayer is allowed, that the separation is set aside, or what you are calling termination.
Termination, yes.
Termination is set aside by this court. Everything has to be restored. Contempt केमती होगा इटा?
The honorable court pass interim
Contempt status quo थिबो कि नहले आपनकर no further action shall be taken. सेमती हेतले हम contempt हबो.
The interim measure, that's why I am file a contempt.
इथे interim order ही नहीं है. Interim order nahi. Interim order in the sense you must, there is no restraint order against them.
Yes.
Whatever action they will take shall be abide and subject to result of the writ application that is there. That will abide definitely. But about content file kale labha kon hela tale.
But they are after honorable court order.
Which order, sir? Which order has been violated? तो पढ़िबे करे. मु तो पढ़िली आपण कहलेनी बोली मु निजे पढ़ी बाहर कली. को order टा violate हेछि पढंतु.
See last para 9.
सेतरे कोटा violate हला. पढंतु.
So abide by the further order.
Yes. Any action taken pursuant to annexure 2 shall abide by it. So that is that they cannot take a plea that though the matter was not within our knowledge, or it cannot be a subject matter of challenge before the court. आपनकर जो ऑर्डर टा को चुने टर्मिनेशन से ऑर्डर डेट केते
11/6 honorable court order pass कले
26/5 है.
26/5
will abide by the order of in the writ application. Even you can amend and file an amendment application to challenge that order if you have not challenged till now. WPC 1686422026, whatever you have challenged, you can amend and challenge also. But how the contempt will be maintainable? Contempt will not be maintainable. Because upon content file kale, the petitioner will be thinking that he will get something. So obviously, he is going to get nothing out of that. You have to challenge, substantive challenge to the order. You have to make it. And there is apparently no violation of any order. I'll pass order that no contempt is made out, or what you say. Because contempt is not maintainable.
I will withdraw the petition.
Contempt application withdraw करिए.
हाँ कौन कौन?
ठीक है video. Mr. Sapan Kumar Pal for the petitioner. C1T3 लिखिए. Mr. Opposite party black रखी था तो. The content application has been listed along with the WPC number 16864 of 2026. The subject matter of the state writ application is not within the determination of this bench. Para. Para, no, stop. However, then comma. Since the petitioner alleges violation of order dated 26/5/2026 passed by this bench as vacation judge, as vacation bench, as vacation bench. They passed by this court as vacation judge. The contempt has been listed along with the writ application today before this court. Perusal of the contempt application indicates that the allegation is for willful violation of order dated 26.05.2026 passed in IA number 10172 of 2026 arising out of WPC number 16864 of 2026. On being asked the learned counsel for the petitioner in the contempt application, upon order a contempt question, right? Refers to paragraph 9 of the order dated 26/5/26 passed in the IA and submits that the said order has been violated by the alleged contemners. In considered opinion of this court, has been violated by the alleged contemners as order of termination and disengagement.
Termination. No, sorry.
How can I be more prepared than you?
No, my lord, this
The order of disengagement dated 11/6/26 annex କରିଛନ୍ତି?
Yes, my lord.
Read annex କଲେଣି?
No, সেটা মনে করি।
Annex to the content application marked as annexure?
Annexure 3, my lord.
Order of termination within court private, ହେଲା? Only. Termination.
Annexure 4.
Disagreement termination तीन चार जो है लाने बर्तन फाइनली है लाने टा termination आउ change होगा. Order of termination जो है within court.
Annexure 4, my lord. 3 and 4.
Due to termination. Only set as a product. Cannot be interpreted to be violative of the order dated
26/5.
order dated
26/5.
26/5/2026. Stop. However, the order as indicated in paragraph 9 in the order of termination, however, the order of termination shall abide by the further orders of this court and shall also abide by result of the writ petition as directed in the order dated 26/5/2026. It is submitted by the learned counsel for the petitioner that at this stage, the learned counsel for the petitioner submits that he would withdraw the contempt application to pursue the writ petition. Stop.
By amendment.
Memo of date. Memo due. He files memo of date indicating his submission, which is taken on record. Scanned copy be updated. The content application is disposed of. The petitioner shall The petitioner shall have the liberty to pursue the remedy as available under law, challenging the order dated 11/6/2026.
amendment ଟା କରିବି amend
Problem होची सेटा मो determination नो ता भीतर मो पसिवाटा फेरे मिस्टर yes Mr. Rajiv Trai तापर line लिखंतु
Yes, madam.
Mr. Rajiv Trai being present in VC addresses submits that he has instruction to appear in the contempt application.
No, not in the contempt, my lord, in the writ petition.
नहीं रीट रे appear करूचंती contempt रे instruction अछि ना नहीं
No, in contempt instruction nahi hai ke, but
अच्छा
you not to rightly observe ki
he appears in the he appears in the writ application on behalf of the opposite parties, which has been listed before this court with reference to the contempt application. Stop. Yes, anything else, Mr. Rai?
No, my lord. Thank
So he withdraws. I think you
Yes,
don't
my
have
lord.
any difficulty to answer that.
Yes, my lord.
Yes.
Item number 17.
my lord.
दूसरे एक steps नहीं आएंगी.
No, मतलब correct address ना वो fresh notice.
तेरा अपना power नहीं. अच्छी.
Power return not on behalf of Mr. Das.
Mr. B. Behra.
N Jena, my lord.
Mr. N. Behra.
N Jena.
N. Jena.
N Jena.
और कुछ जगह आपको बता रहे. Mr. N. Jena on behalf of Samir Kumar Das for the petitioner. Opposite party blank. The Lord Counsel for the petitioner submits that further time may be granted to obtain the present correct address of the opposite party number 3. Accordingly, for the
2 weeks,
15 days,
my lord.
for the accordingly for the 2 weeks time granted, the petitioner shall take steps for discovery of the present correct address and filing of the same before this court. Upon filing of the present correct address and the requisites for issuance of notice, the office shall do well to issue notice to the opposite party number 3. Afresh. Fixing a returnable date. The matter shall be listed for orders in the week commencing 17.
Obliged.
Item number 18.
Petitioner none. क्या अच्छा नहीं? बीसरे के नाम था?
No.
Petitioner none appears for the petitioner when the matter is called. Petitioner is also absent on repeated calls. On 24/6/2026, none had appeared for the petitioner and the following order was passed. Stop. The efforts of this court to intimate the order to the learned counsel for the petitioner has not yielded any result. Stop. Though the matter was presented before this court on 15/2/2022, for the last more than 4 years, no steps are taken on behalf of the petitioner to remove the defect as pointed by SR regarding change of nomenclature from RPFAM to CRLFP. Stop. In considered view of this court, no purpose would be served in keeping the matter pending, effective, without there being any steps on behalf of the petitioner. Stop. The petition is disposed of accordingly. Yes,
Item number 19.
Item 19, may I please, Lordship? I'm appearing
Yes,
through
Mr.
VC.
Samal for the petitioner. Yes, Mr. Samal.
My Lord, I seek further time to remove because last occasion, Your Lordship, pursuant to Lordship's order, I could not do.
So, sir, what about 4 years and 4 months? Is not adequate. Because if
Lord,
by passing the order,
Lord.
I have to, I may not say it obviously in so many terms, so many words, but it must make any sense. After 4 months, I'll be granting time to removal of defect. Anyway, do it because I always grant time. So,
Mr.
Mr. Siddhartha Samal for the petitioner.
My lord.
The efforts of this court as well as the registry to intimate the petitioner, intimate the learned counsel for the petitioner regarding the listing of the matter and taking steps for removal of defects as it did result. Stop. The learned counsel for the petitioner appears in VC and submits that further time may be granted to remove the defects. Stop. He is apprised of the fact that the matter is pending since it was presented on 17/2/2022. Stop. Taking rather a lenient view, further how much time, Mr. Samal?
By next week, I will take the lord.
For
Because I am ill, my
the
lord.
time is
By
granted, the
next week,
defects as
definitely.
pointed shall be removed within 10 working days. The matter shall be
lord.
listed for orders in the week commencing 3/8/2026.
My lord.
Item number 20.
Oblige me.
Mr. R. Mahato for the petitioner. Ms. Dipti Dhal for the opposite party. Mr. Mahato.
May I please, my lord? My lord, here, my lord, the present RPFM has been preferred by the husband, wherein the enhancement order passed under section 125 of 127 of CRPC has been challenged. Lordship, originally,
So 125, whatever was awarded, you are paying that.
not in 125, my lord. The actually maintenance was awarded in MAT case number 495 of 2007.
127 it is that matter where 127 has been wrongly cited as the provision.
Not wrongly cited, my lord. It was wrongly filed.
Correct. Cited by the lawyer
which is actually barred by jurisdiction, my lord. Lordship, may allow me to explain? I will explain.
I think it was discussed. Kindly. Earlier order Ruchi. Order ta dekho 10-3. Madam, kindly look at the order. Apanar Ochi. No, later dekho. Mr. Mahato, you can shift to the other paperless. So she can order dated 10-3. About to get that dekhi.
Yes, my lord. At that point of time, Lordship has raised me a question regarding overlapping of jurisdiction, my lord. Lordship starts from
Para 4 dekho to apana contention ta.
It is submitted that section 25 of the Hindu Adoption and Maintenance Act 1956 is the appropriate provision for seeking enhancement of the amount awarded. While allowing the MAT case number 495 of 2007, the Learned Civil Judge Senior Division had directed the payment of maintenance of ₹3,000 to the wife in the marriage and 1,500 to the child. It is submitted that the Learned Judge Family Court 2 Bhubaneswar could not have passed order under section 127 of the CRPC for enhancement of the amount. Thereafter, my lord.
In response to the said submission.
Yes, my lord.
Please that.
In para 6, Lordship may continue. Para 6. Further, it is brought to the notice of the learned counsel for the petitioner that in the judgment rendered in Rajnesh versus Neha.
Are you going? You are able to get the page, na?
Okay.
Yes, please read. Yes.
Decided on 4/11/20, the Honorable Supreme Court have issued guidelines regarding the issue of overlapping jurisdiction, that is, jurisdictions exercised by the various courts under various provisions such as Section 125 CRPC and Domestic Violence Act, in which applications are usually made before the magistrate. Section 24 and 25 of Hindu Marriage Act. Read with subsections for which jurisdiction is exercised by the learned judge, family court, or civil judge, senior division, as the case may be. Further, the jurisdiction under Section 18 and 25 of the Hindu Adoption and Maintenance Act to be exercised by the civil judge, senior division. To avoid the conflicting and multiplicity of orders by several courts, which at times causes hardship for both the parties to claim for maintenance, that is the person who is seeking maintenance and the person who is to give the maintenance. The usual practice after the directions issued by the Honorable Supreme Court in Rajneesh Supra is that all such claims for maintenance are being entertained by the learned judge, family court. And thereafter you
are saying that 127
is barred by jurisdiction, my lord. Why I am saying so? My lord, family court is a specialized court which only deals with the matter related to matrimonial issues. It invokes both the civil jurisdiction as well as the criminal jurisdiction, my lord. In Rajneesh versus Neha also, in para, where the overlapping of the proceedings were been given, stated, it was specifically given that the maintenance can be awarded in other proceeding also, but not in the both the jurisdiction cannot be invoked in one proceeding, my lord. Such as, for an instance, if a maintenance has been awarded in Hindu Adoption and Maintenance Act, simultaneously, a wife can also seek a maintenance under Section Hindu Marriage Act in a pendulite under Section 24 also. In that case, it can be said that enhancement can be, because it is under the same jurisdiction in a civil form. But the original order was not been passed under Section 125 in the present case, my lord. In the present case, the maintenance award has been passed under Section 18 and 20 of the Hindu Adoption and Maintenance Act. And this is the subsequent remedy which she has been sought. She has get, sorry. The original remedy was from
this could have been avoided by what? By a little reading of the law by the lawyer.
Yes, ma'am.
Yes, Madam Dhola, what can be done?
Enhancement पे 127 रे ସେମାନେ ପକେଇଛନ୍ତି କୋର୍ଟ ଅର୍ଡର କରିଛନ୍ତି
କେମିତି ହବ ଆଜ୍ଞା?
ଇଷ୍ଟ କୋର୍ଟ ରେ
ମୁଁ ତ କରିପାରୁନି, ମୁଁ ତ ବହୁତ ଜିନିଷ ମୁଁ କରିପାରୁନି, ହାଇକୋର୍ଟ ହେଇକି ବହୁତ ଜିନିଷ କରିପାରୁନି, ମୋର ପ୍ରୋଭିଜନ ନାହିଁ ବୋଲି।
ରେଲୱେ ରେ ସେ ଚାକିରି କରୁଛି, ରେଲୱେ ରେ ଚାକିରି କରୁଛି, ସେ ଗୋଟେ ପୁଅକୁ ଆଉ ତା ସ୍ତ୍ରୀଟାକୁ ଦବ, ଆଉ କଣ ପୁଅଟା ବି ପଢୁଛି ଏମଏସସି କରୁଛି।
No, see, now the son has got attained the age of majority.
ମେଜରିଟି କଣ ପଢୁଛି ସେ ଆଉ ଗୋଟେ ଷ୍ଟୁଡେଣ୍ଟ ଆଉ ଏନହାନ୍ସମେଣ୍ଟ ପାଇଁ କରୁଛନ୍ତି।
ଆପଣ 127 କୁ ପଟନ ପ୍ରୋବ୍ଲେମ ହେଲାଣି, ଆପଣ 127 କୁ କୋଉଠୁ ଆଣିଲେ ତା ଭିତରେ ଫାଇଲ କରିଦେଲେ, କୋର୍ଟ ବି ତାକୁ ଦେଖିଲେନି, ରେକର୍ଡଟା ଦେଖିନଥିବ। ପ୍ରୋବ୍ଲେମ ହଉଛି କଣ କି ରେକର୍ଡଟା ଦେଖିନାହାନ୍ତି। In fact, when it was heard, this point was noted. This point has been noted. ଆପଣ ସେକ୍ସନ 18 ରେ ଯଦି ଅର୍ଡରଟା ହେଲା, ଏନହାନ୍ସମେଣ୍ଟ କେମିତି ହବ?
127 ରେ ସେମାନେ କଲେ
କୋଉଟା ଦେଖୁନାହାନ୍ତି, ସେକ୍ସନ 18 ଟା ଦେଖନ୍ତୁ, ଟିକେ ଦେଖି କହିବେ ଫଟଫାଟ ଉତ୍ତର ଦେବେ। ଏମିତି ତ ଫଟଫାଟ କରିକି କେସଟା ଗଲା,
ଆଜ୍ଞା
ଦେଖିଲେନି ପ୍ରୋଭିଜନ, କିଛି ଭାବିଲେନି।
Another thing, my lord, already decree of divorce has been passed, that order has not been challenged.
The decree of divorce will not bar the parties from getting maintenance.
Yes, yes, that is right, man.
ମୋର ପାଇଁ ବହି ଅଛି ମ୍ୟାଡାମ, ଆଣିଛନ୍ତି?
ନାଇଁ
Adoption and Maintenance Act ଦିଅନ୍ତୁ, ଆଉ ବହି କାଢନ୍ତୁ। ଅଛି ସେଠି ଆଉ ଏଇଟା ନିଅନ୍ତୁ। Section 25 पढ़ो तो बट kindly read it aloud.
Amount of maintenance may be allotted on change of circumstances. The amount of maintenance, whether fixed by decree of a court or by agreement, either before or after the commencement of this act, may be allotted subsequently if there is a material change in the circumstances justifying such alteration.
About 25 application guy. Where is your 25 application?
Yes, my lord. 25 रे ସେମାନେ ଫାଇଲ କରିଥିଲେ ଯୋଉ ମେଣ୍ଟେନାନ୍ସ ପ୍ରଥମ ପାଇଥିଲେ ସେକେଣ୍ଡ ରେ ସେ ମେଣ୍ଟେନାନ୍ସ ଏନହାନ୍ସମେଣ୍ଟ ପାଇଁ ଗଲେ 127
25 ରେ ଫାଇଲ करता प्रथम पिटिशन देखो 18 नहीं प्रथम पिटिशन देखंतु
ଆଜ୍ଞା 27 ରେ ସେମାନଙ୍କର ଅର୍ଡର
18 section 18 रे आपण प्रथम पिटिशन देखंतु 18 हेतिबो
18 and 20 subsection 2 of Hindu adoption and maintenance.
About 25 application काई
ନାହିଁ ଥିଲା କିନ୍ତୁ
could ଆସିବା ଆগে that is the point. So one thing can be done that this court will grant you liberty to file application under section 25 and this order has to go. This pressure of disposal and the lawyer not being concerned with what is the provision and what is to be argued ଆପଣ file କରିଦେଲେ your effort to get maintenance was to help your client or not. I mean whoever was the counsel, you were not the conducting counsel. But ଆପଣ file କରିଦେଲେ CRPC ରେ CRPC is to be tried 125 is by the magistrate.
ସେ ଅର୍ଡର କେମିତି ତଳ ପଟ କେମିତି ଅର୍ଡର କଲେ ତ ପୁଣି
ମୁଁ କଣ କରିବି ଆଜ୍ଞା ମୁଁ ତ କଣ
ଅର୍ଡର କଲେ ତ ପୁଣି ସେ ଏନହାନ୍ସମେଣ୍ଟ ପାଇଁ କଲେ କେମିତି ସେ
That is how our system is that the judge is to be educated by the lawyers. Whatever the lawyer educated the judge, he passed the order. ଟିକେ ଯଦି ରେକର୍ଡ ଟା କଲ୍ ଫର କରିଥାନ୍ତେ ଦେଖିଥାନ୍ତେ ତାହେଲେ ଭୁଲ ହେଇନଥାନ୍ତା
ଦେଇନାହାନ୍ତି ରେକର୍ଡ
ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି there is apparent lack of diligence. Some of the parrot is very happy to come to the fifth floor and sit at the window seat. এটা কিছু করি হবনি nothing.
ରହିଯାଉ ନହେଲେ ଆଉ ଗୋଟେ ଡେଟ୍
ଆଜ୍ଞା
ଆଉ ଗୋଟେ ଡେଟ୍
ଆଉ ଗୋଟେ ଡେଟ୍ କୁ ରଖନ୍ତୁନି ଆପଣଙ୍କୁ ଗୋଟେ 3-4 ଥର ଆପଣ ଯେତେଥର ମେନସନ କଲେଣି ଏତେ a lot of effort was made on the 10/3 ଏବେ 4 ମାସ ପଳେଇଲାଣି. On 10 March also I asked you this question that how this order can be sustained. ଆପଣ ଯେତେବେଳେ 302 ରେ ଧରନ୍ତୁ ଜଣ କନଭିକ୍ସନ ହେଇଗଲା କୋର୍ଟ କରିଦେଲେ ପୁରା ଟ୍ରାଏଲ ହେଲା 200 ରେ ଆଉ ଗୋଟେ ଏକ୍ସଟ୍ରିମ ଏକ୍ସାମ୍ପଲ ଦଉଛି କଣ ହେଇପାରିବନି ଟ୍ରାଏଲ ଯେମିତି ହେଇପାରିବନି ସେମିତି ପ୍ରୋଭିଜନ ଆପଣଙ୍କର ଯୋଉଟା ଭୁଲରେ ସେଇଟା ମେ ବି ଆପଣଙ୍କର ପ୍ରଥମ ଅର୍ଡରଟା ସେ ବିଲକୁଲ ଦେଖି ନାହାନ୍ତି ପ୍ରଥମ ସେକ୍ସନ 18 ଅର୍ଡରଟା କାହିଁ ଯୋଉଟା ଆପଣ ମୁଁ ପଚାରୁଛି
This is the order, my certificate.
ସେଟା ଏଥିରେ ଫାଇଲ ହେଇନି
ନାଇଁ ଆଜ୍ଞା ସେଟା ଫାଇଲ ଏ ପଛରେ ମିଳିଥିଲା
ଗୋଟେ ଫଟୋ ଉଠାନ୍ତୁ ପଳେଇଲା ମ୍ୟାଡାମ ଏଇଟା ଅଛି ଆପଣଙ୍କ ପାଖରେ
ନା ମୁଁ କୋଉ ନାହିଁ
ଏଇଟା ଦେଖନ୍ତୁ ଏଇଟା ମୁଁ ଏଇଟା ଆପଣ ପଚାରୁଛୁ ଦେଖନ୍ତୁ ଜଷ୍ଟ ଗୋଟେ ଆମେ ଫାର୍ଷ୍ଟ ଲାଇନ ଟା ପଢନ୍ତୁ ଆପଣ ବୁଝିଯିବେ The petition, पढ़ंतु.
The petitioner has filed the MAT case number under section 18 read with section 22 of the Hindu Adoption and Marriage Act.
That clinches the issue. ସେତିକି ଯଦି ଆପଣ ଦେଖେଇଥାନ୍ତେ ଟିକେ କୋର୍ଟରେ, I don't know what has happened.
କରିଛନ୍ତି ଆଉ ସେମାନଙ୍କର 22 ମସିହାରେ ସେମାନେ ଏନହାନ୍ସମେଣ୍ଟ ପାଇଁ କରିଥିଲେ।
Whatever I get, that is the basic order ଆପଣଙ୍କର ବର୍ତ୍ତମାନ ଜଜମେଣ୍ଟ ଦେଖନ୍ତୁ।
ଆଜ୍ଞା।
Just now come to the page at annexure 1 ରେ ଦେଖିଲେ present order ଟା ଦେଖନ୍ତୁ 127 order ଟା ଦେଖନ୍ତୁ।
ନା ଆଉ ଗୋଟେ ଡେଟ୍ କରଉନ।
ନାଇଁ ନା ସମୟ ନଷ୍ଟ କରନ୍ତୁନି, you have spent 4 months for nothing।
ଏଟା କ୍ଲାରିଫାଇ ହେଇଯାଏନି।
ଆପଣ କ୍ଲାରିଫାଇ କଣ ହେବେ? ମୁଁ ତ ବର୍ତ୍ତମାନ ପୁରା ସବୁ କ୍ଲାରିଫାଇ 4 ମାସ ହେଲା କରିକି ଆପଣ ବୁଝେଇକି କିଛି ଲାଭ ନାହିଁ। ତ ଆଉ ଗୋଟେ ଡିଫିକଲ୍ଟି ହଉଛି ଯେ ଆପଣ ଏ କେସରେ this matter is kept pending and the petitioner would be thinking that if you find from the order wherever it is referred, ଆପଣ ଯୋଉଟା impugned order ରେ ସେ ବିଲକୁଲ ରେଫର କରିନାହାନ୍ତି ଅରିଜିନାଲ ଅର୍ଡର ଟାକୁ।
ତଳପଟ କେମିତି ଅର୍ଡର କରିଦେଲେ ଯେମିତି କଣ?
ସେଟା ଆପଣଙ୍କ ପିଟିସନ ପାଇଁ
ମନ ଇଚ୍ଛା ଅର୍ଡର କରିଦେବେ।
ମନ ଇଚ୍ଛା ପିଟିସନ କଲେ ମନ ଇଚ୍ଛା ଅର୍ଡର ହେଲା। କିଏ ଟ୍ରଷ୍ଟ କରିବ ଯେ ଆପଣ ପଢିକି ଆସିନାହାନ୍ତି ବୋଲି, ବିଲକୁଲ ଦେଖି ନାହାନ୍ତି ବୋଲି? ହାଉ ଆଇ ୱିଲ୍ ଟ୍ରଷ୍ଟ ୟୁ? ସରି ଆଇ ୱିଲ୍ ସସ୍ପେକ୍ଟ। ଓଲଟାଟା କହିଦେବି। ମୁଁ ତ ଟ୍ରଷ୍ଟ କରୁଛି ନା ଯେ ଆପଣ ପିଟିସନ ଫାଇଲ ଠିକ କରିଥିବେ ବୋଲି। ଆପଣ ଆଣିଲେ 127 ଫାଇଲ କରିଦେଲେ, ତାକୁ ମୁଁ ଆଲାଉ କରିଦେଲି। ତାପରେ ଆପଣ କହିଲେ ଆପଣ କିନ୍ତୁ 127 ଆଲାଉ କଲେ, 125 ଅର୍ଡର ନାହିଁ। କିନ୍ତୁ ତ ଏତେ କ୍ରସ୍ ଚେକ୍ ତ କରି ହଉନି। ବଟ୍ obviously there is no excuse for this। ସେଟା ଆଉ ଗୋଟେ ଜିନିଷ। ବଟ୍ ଆପଣ 120 ଆପଣ 25 ରେ ଫାଇଲ କରିଥିଲେ କି? which I have been asking you, ଯୋଉଟା କି ଆପଣ କହିପାରୁନାହାନ୍ତି because you have never filed any 25 application।
125 ରେ ଫାଇଲ କରିଥିଲେ।
25 ଧାରାରେ
ହଁ
କରିଛି
ଯେ ମୋ ପାଖରେ ନାହିଁ ଅର୍ଡରଟା ବୋଧେ। ମୁଁ ଦେଖେ ଆଉ ନାହିଁ ଅର୍ଡରଟା।
ଆପଣ ତ ଦେଖିବେନି ଉପରଟା ଆଉ। ଏଠି ଆଉ କଭର ଅପ୍ କରିହବନି। ଉପରେ ଦେଖନ୍ତୁ ଆପଣ ଯୋଉ CMA 139 of 2016 ଲେଖିଛନ୍ତି ସେଥିରେ that is not under section 18।
So first line ରେ ଲେଖା the mother of the petition number 1 has filed a petition under section 127 of the CRPC।
ଗୋଟେ ଡେଟ୍ କରଉନ।
ଏତେ ଡେଟ୍ ରେ କିଛି କରିହବନି। ଆପଣ ବୁଝିପାରୁନାହାନ୍ତି କଣ ନେକ୍ସଟ ଡେଟ୍ ରେ କଣ କରିବା କହିଲେ?
ନେକ୍ସଟ ଡେଟ୍ ଦେଖି ସେ ଅର୍ଡର କଣ ଥିବ ଦେ ଅର୍ଡରଟା ଦେଇନି ମତେ।
ଆଜ୍ଞା ଆପଣ ତ ନିଜେ ଫାଇଲ କରିନାହାନ୍ତି, କୋଉଠୁ ଆଣିବେ? ଆପଣଙ୍କ ପ୍ରୋବ୍ଲେମ ଯେ ଆପଣ ହଉଛନ୍ତି ଆପ୍ଲିକାଣ୍ଟ, ସେ ହଉଛନ୍ତି ଡିପେଣ୍ଡେଣ୍ଟ। ସେ କଣ ଦେବେ ଆପଣ?
ସେ କଣ ଜାଣିକି
ଆପଣ ବର୍ତ୍ତମାନ କଣ ଆପଣ ଯୋଉ 4 ମାସ ହେଲା ସମୟ ନଷ୍ଟ କଲେଣି, ଆ ଭିତରେ you should have filed your application, it should have been disposed of on that day itself। You must look at the interest of your client। Order dated 10/3/2002 आज लिखिए appearance लिखिए। The learned counsel for the petitioner as well as the opposite party were had at length। आरंभ करिवे the order dated 15/10/2022 the 10 order ରୁ ଅଛି। को पैराग्राफ डाकिली para 2 रे सब para the order dated 15/10/22। then para 3 para 4 ନା
ମାଇନଟା ଗୋଟେ ଡେଟ୍ ରହୁ ତାପରେ
ଯୋଉଥିରେ ଆପଣଙ୍କ କ୍ଲାଏଣ୍ଟ ର କିଛି ଲାଭ ହବନି, କ୍ଷତି ହବ, ଆଡଜଷ୍ଟମେଣ୍ଟ କରନ୍ତୁ ନାହିଁ। make it a golden rule of your practice। by keeping this matter pending, are you helping your client? Because you are saying that the child is studying, the mother is single mother, she has to fend for herself। so they require what? They require a order of maintenance of enhancement। how they will get it? by filing an application। under which provision?
25
of Hindu Adoption and Maintenance Act। so sooner the application is filed, better for them। But by filing this, you are trying to sustain an unsustainable order. Now let us assume that I pass a wrong order. I could have passed on 10-3, could be. ଶୁଣନ୍ତୁ ମୋ କଥାଟା ଶୁଣିଲେ ବୁଝିପାରିବେ. Suppose I pass a wrong order, then you can go to Supreme Court. ବର୍ତ୍ତମାନ ଆପଣ ନା ମେଣ୍ଟେନାନ୍ସ ପାଉଛନ୍ତି ନା ଆପଣଙ୍କ କେସ୍ କିଛି ସମାଧାନ ହଉଛି. So either way you are not getting anything for your clients. That you should never do. ଆପଣ important part ଟା ବୋଧେ ମିସ୍ କରୁଛନ୍ତି. I told you that you will have the liberty to move. By blaming the court जे से किंते 127 ने फाइल कर देले, are you getting anything? Court तो भूल कले, ठीक अछि. But is the mother and the son who is prosecuting his studies, engineering ना कौन पढ़ुचंदी, are they getting anything? They cannot get anything. कौन लिखे? हाँ, 3-4 एक रा 2 ର ସପାରା the order dated 15-10 ସପାରା ତାପରେ 3-4 in this it was further directed by order after ତାପରେ ଲେଖନ୍ତୁ having heard learned counsel for the petitioner as well as the opposite party by order dated 10-3-2026 the following was directed. The following was observed. Following was observed, not directed, observed. 4-5-6-7 The learned counsel for the opposite party reiterates her submission that para 9 judge say order में the opposite party wife in the marriage as well as the child making not to be interfered with. In response to the order dated 10-3, it is submitted by the learned counsel for the petitioner that the learned judge family court English 2 did not have jurisdiction to entertain an application under section 127 of CRPC, which is a different statute other than the Hindu Adoption and Maintenance Act, 1956, wherein the original order directing payment of maintenance was passed in an application made by the present opposite parties under section 18, read with section 20 of the Hindu HA and M Act 1956. It is referring to the decision rendered by the Honorable Apex Court in Rajneesh versus Neha, as was cited in the order dated 10-3-2026 of this order. It is submitted by the learned counsel, learned counsel for the petitioner, that regarding overlapping jurisdiction and different proceedings to be taken up by one court to avoid conflict of views as well as difficulty to the parties, his submission would be the said direction, the matters to be taken up by one court was in the context of the applications filed under Hindu Marriage Act seeking maintenance such as section 24 and 25, application filed seeking maintenance under section 125 CRPC into bracket to 144 PNS is closed, and application filed under the prevention of domestic violence DV Act, wherein in all such applications maintenance is sought for It is further submitted that he further submits that in the case at hand, such is not the scenario. Rather, the opposite parties had sought for maintenance under the provisions of HA and M Act 1956, which was awarded, and the court to exercise jurisdiction to enhance such award has to be in terms of Section 25 of the said Act. For convenience of reference, the Section 25 of the HA and M Act 1956 is reproduced herein. Learned counsel for the opposite party in her response submits that the petitioners require enhanced maintenance. The opposite parties being the petitioners before the learned family judge Bhubaneswar required enhanced maintenance, and accordingly they approached the court. However, she does not dispute that the application was made under Section 127 of the CRPC. Stop. Para. This court has to take note of the obvious mistake in approach of the learned judge family court in proceeding with the matter under a different provision not contemplated in the statute, also not directed in Rajneesh versus Neha. Somehow, somehow, comma. The judgment also does not refer to the application, refer to the earlier application or the judgment made therein under Section 18 and 20 of the H&M Act. HA and M Act. So, that could be the reason for the learned court to proceed erroneously in absence of the petition filed before the court. A copy of the petition filed before the court, as it is upon petition copy nahi.
Co-petition
ये जो 127 petition है.
ना petition copy नहीं.
In absence of the copy of the petition under section purportedly filed under Section 127, copy of the petition copy. In absence of the copy of the petition, the learned counsel for the parties are also unable to assist. In view of the above discussions, the order dated 15-10-2022 cannot be sustained. 15-10-22 passed in CMA number 139 of 2016 by the learned judge family court dash Roman 2 Bhubaneswar cannot be sustained. The same is set aside. Arana diyo to original. Xerox करके नहीं आसो. आर copy होचे अपन पाकर.
No, in course of the day I will supply.
The copy of the MAT case number 495 of 2007. Certified copy of the MAT case number 495 of 2007 filed by the present opposite party, parties, wife and child. The present petitioner being the opposite, being the respondent, is produced by the counsel for the petitioner. Copy of the said petition is retained, and the certified copy is photocopy of the said petition is retained. Certified copy is returned. It is further clarified and directed that the present opposite parties shall have the remedy of approaching the learned court of jurisdiction under Section 25 of the
HAM.
and M Act 1956 for enhancement of the monthly maintenance at the rate of rupees 3,000 for the wife in the marriage and rupees 1,500 for the child, as directed by order dated 12/8/2010. Passed in MAT case number 495 of 2007 by the Civil Judge, Senior Division, Bhubaneswar. But it is further clarified that since the earlier application under section 125 of CRPC, 127 of CRPC was filed on 26/11/2016, registered as CMA number 139 of 2016, which has been set aside. The application of the present opposite parties shall be considered taking taking 26/11/2016 ଆପଣ ଏଠି କରୁଛନ୍ତି ନା ଏଠି କରିଦିଅ that will be simpler 26/11/2016 as the date of application. With the aforesaid it a writ petition. The revision application is allowed with allowed and disposed of with the above observations. Yes, Ms. Dora. ସେଟା ପୁରା ଆପଣଙ୍କ ଲିବର୍ଟିରେ ଗୋଟେ ଲମ୍ବା ପାରାଗ୍ରାଫ ପୁରା ଯାଇଛି ଡିଟେଲ ଡିସ୍କସନ ହେଇଛି ଆପଣ ସେଟା ଆର୍ଗ୍ୟୁ କରିବାର ଥିଲା ଆପଣ ଯଦି ଆଜି ବି ଆର୍ଗ୍ୟୁ କରିଥାନ୍ତେ ହେଇଥାନ୍ତା ଆପଣ କଲେନି କିନ୍ତୁ ଆଜି ଦୃଷ୍ଟିରୁ ଭଲ ହେଲା ଯେ ଆପଣଙ୍କ ଆର୍ଗୁମେଣ୍ଟ ବି ରହିଲା ସବୁ ରହିଲା ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଗଲା ନାଉ ଆଟଲିଷ୍ଟ ୟୁ କ୍ୟାନ୍ ଥିଙ୍କ ଫର୍ଦର ନହେଲେ ଏଇଟା କେମିତି ପଢିକି ରହିଥାନ୍ତା yes
item number 21
ଆପଣ କେବେ କେତେ ଦିନରେ ଫାଇଲ କରିବେ The petitioner shall have liberty, the opposite party shall have liberty to file the application on the section. ମୁଁ କହୁନି ଛାଡି ଦିଅନ୍ତୁ ବର୍ତ୍ତମାନ ସେଟା ଆପଣ ଫାଇଲ ନ କଲେ ସେ କହିବେ ଯେ ସେ 4 ସପ୍ତାହରେ ଫାଇଲ କଲେନି ଦେଖାଯାଉ ଠିକ ଅଛି let us hope for the best ହେଲା
21
For the petitioner wife,
yes,
the noting is showing that the notice is unserved due to address is left. I have to fresh address, my lord. Kindly allow me 1 week time to text it.
Mr. Abhit Sahu for the petitioner, opposite party blank.
Dr. Jyoti Prakash Pani, husband.
Blank. Ukila blank.
My lord.
ନା ଆପଣ appear କରିବେ
ନା opposite party notice ହିଁ ଯାଇନି
opposite party blank ହିଁ ରହିବ
black
ଆପଣ opposite party କୁ ମାନେ ସଂଯୁକ୍ତା ପାଣି versus ଜ୍ୟୋତି ପ୍ରକାଶ ଭାବିଲେ blank କି ନାହିଁ I remember because I told Mr. Mishra that I am also Pani. So that is how I checked the names because those names are also similar to my cousin. So
yes,
opposite party blank. The office note indicates that notice issued to the opposite party by order dated dash has been returned unserved with postal endorsement, address left, hence returned to the sender. It is submitted by the learned counsel for the petitioner that the petitioner shall make effort to find the present correct address of the opposite party and take steps for issuance of notice of face. Para prayer is allowed. The petitioner shall furnish the present correct address within a period of 2 weeks.
1 week is enough because I
ଆପଣ କାଲି ଦେଲେ ବି ହବ
yes, man, 2 weeks.
2 weeks ଦେଲେ ଏହା ଲାଭ ଯେ ଏଟା ବାରମ୍ବାର ଲିଷ୍ଟ ହବନି I have at least eliminated ଏ ଯୋଉ not compliant, not amko, not samko କରି ମେଞ୍ଚେ ଅର୍ଡର ହବ granted 2 weeks time to furnish the present correct address. Stop. Upon furnishing of the present correct address, notice be issued to the opposite party afresh, fixing returnable date. The unutilized copies of requisites shall be utilized.
Deeply.
Mr. Shankaracharya Chaudhary for the petitioner. Opposite party भी ना mention नहीं थे, पर mention को थी.
और ना दिया wood development detail.
हाँ, सेट में मध्य ना. Opposite party blank. Shankaracharya Chaudhary को तो not थी, mention तो ही नहीं.
No.
The petitioner blank, opposite party blank. None appears for the petitioner of the opposite party when the matter is called. The counsel for the petitioner was heard at some length on 15/1/2026. And the following order was passed. Memo dated 11/5/2026 has been filed by the petitioner. Also, countersigned by the learned counsel for the petitioner. Has been filed, signed by the petitioner. Signed by the petitioner, also countersigned by the learned counsel for the petitioner, which states thus: the petition is accordingly disposed of. Next.
23.
So Sanjeev Mohanty for the petitioner. So Sashwat Das for the opposite party. CMAPL
restoration that was dismissed for default.
Dismissed for default.
My lord.
Military Florani
Usually I never object because the even the plea taken is the learned counsel who was earlier conducting the case. He is no more there. That is what
Mr. Girish Mahapatra, late Girish Mahapatra was conducting this case.
But here what has happened, my lord, initially in 2003, he filed the writ petition seeking regularization of his service from a particular date. Now that matter first listed in 2003, then subsequently in 2024, when it was dismissed for non-prosecution. In the meantime, in 2017, the service of the petitioner was regularized, giving retrospective effect from 2015. So the relief claimed in the writ petition has already been granted, maybe from a different date.
So what can be done? What can be done that you bring that on record?
Yes.
That would be better. So that at least I don't have to look into the merits, because technically I cannot look into the merits in CMAPL.
Yes.
If the writ petition is restored, whatever developments have been there, you have to bring it on record. And then it is for Mr. Mohanty to decide and the client to, the person to decide.
And this restoration application has been filed nearly after 1.5 years.
Service matter does.
Yes, yes. Your lordship. Only I was just trying to bring all the facts to your lordship.
Your point is well taken. That and perhaps by keeping the matter pending is of no use because he has already got the relief. But ठीक है अपना आसू सेटा.
Yes.
Record रे आसू सेटा. CMAPL लिख ले. The CMAPL has been filed
for interruption. That is.
अगर cost देवे ना कौन?
No.
अधिया कौन होगा?
नहीं खेल डिबोटी
देवे नहीं.
जब वो dismiss है
C cost मगुना दे अपन के दाम interested.
When it was dismissed,
the writ application was dismissed for non-prosecution by order dated 4/1/2024.
24.
It is submitted by the learned counsel for the petitioner that the learned conducting counsel unfortunately passed away during the pendency of the writ application. Therefore, there was a definite gap in attending the matter. Thereafter, petitioner having the knowledge of the dismissal has filed IA number 548 of 2025. The IA Sangare Rakhibe. Perusal of the record available office record, the available order sheets indicates that notices were issued by the division bench, then having determination of the subject, determination of the matter on 21/3/2005. Thereafter, the matter was not listed. So, ଆପଣ ଏଟା କାଉଣ୍ଟରଟା ଫାଇଲ କରିଛନ୍ତି ରିଟ୍ରେ ନା ଏଥିରେ?
ଏଇଥିରେ ଗୋଟେ objection ଦେଇଛୁ to the IA application because there is a application for condonation of delay and another
page 47 ଟା କଣ counter to the writ application?
page 47 ଟା counter to the
କାର counter?
That is a counter to the writ petition.
we have also given a counter to the CMAPL. CMAPL ଗୋଟେ counter ଦେଇଛୁ.
नहीं, just look at the paperless 47 ଟା କଣ? June 2006. रीटा खोलचोती तो तो रीटा अलगा बुक मार्क रे अछि जो लाइव लिंक नहीं कि रीटा अलगा सीएमपीएल अलगा रीटा खोलो
Yes. Writ petition 1 counter affidavit has been filed by 2 and 3.
कौन काउंटर पाइना दी?
No, I have already got the counter.
कौन लिखे? Perusal of the records of the writ petition, which has also been tagged to the CMAPL, indicates that counter affidavit on behalf of the opposite party was filed on 19 June 2005. छह से देखा जो नहीं नंबर डेट टा ठीक है उन्होंने फिजिकल कॉपी देखी थी उनको 2005 है जो
नहीं 2006 19 जून 2006 19 जून 2006 The learned counsel for the opposite party submits that he has filed, referring to the counter filed to the same APL, submits that apart from the delay in filing the same APL, the further developments have to be noted as to whether revival of the writ petition would lead to any positive result for the lead to any result for the petitioner. Having heard learned counsel for the petitioner and the learned counsel for the opposite party, in considered view of this court, the matter being pertaining to regularization in service, regulation in service, in the establishment of the opposite party university, and the fact that the learned counsel for the petitioner unfortunately passed away during pendency of the petition, the writ petition needs to be revived to be considered on merits. The CMAPL is favored and disposed of. Taking note of the submissions of the learned counsel for the opposite party, the opposite parties shall file their affidavit indicating the subsequent developments after filing of the counter affidavit, which is on record, to be tagged to the writ petition. Writ petition the determination the court na court ko. Batan bade court. Reality as not that. Writ petition lekhantu the
2003
the same appeal number 328 of 2025 have been allowed. The writ petition 10693 of 2023 is restored to file. It is actually same appeal. The same appeal is favored and disposed of. The writ petition is restored to file. The writ petition is restored pursuant to the order passed in same appeal number 328 of 2025. It is submitted by the learned counsel for the opposite party university that as the events have unfolded, the petitioner has been regularized with effect from regularized in the post of
artist
your lordship.
artist
With
with effect from
petitioner, one has been regularized and other your lordship is still in service.
petitioner one he jechindi trilochana hele artist hele na ki artist hele
ଦି ଜଣ ଯାକ artist.
regular ଆଜ୍ଞା ki hele ଆପଣ ତ ଦି ଜଣ hele regular je gele କେମିତି
regularized by the order dated 16/8/2017 with effect from 7/9/2015.
नहीं ସାର୍ କହୁଛନ୍ତି ତ୍ରିଲୋଚନ ଆଉ ସୁଶାନ୍ତଙ୍କ ଭିତରୁ ଜଣେ ହେଲେ ରେଗୁଲାରାଇଜ ଆଉ ଜଣେ ହେଇନାହାନ୍ତି
ଦି ଜଣ ଯାକ ହେଇଗଲାଣି in the meantime.
ନାଁରୁ ଜଣା ପଡୁଛି ତ୍ରିଲୋଚନ ହେଇଥିବେ ଆପଣଙ୍କର ମିଷ୍ଟର ଦାସ ଚେକ୍ ୟୁର ନୋଟିଫିକେସନ
that is what I am checking.
ସୁଶାନ୍ତଙ୍କ ନାଁ ଯଦି ଥିବ
Serial number 2, it is there.
ଦି ଜଣ ଯାକ ହେଇଛନ୍ତି
Sushanta's name and Trilochana.
ଆସୁନାହାନ୍ତି ମିଷ୍ଟର ମହାନ୍ତି ଆପଣ ଜାଣିବି ନାହାନ୍ତି ତାଙ୍କ ବିଷୟରେ
ନାଇଁ ନାଇଁ ସେ ଆସୁଛନ୍ତି ତାଙ୍କର କ୍ଲେମ ହଉଛି from the initial date of engagement.
ଦି ଜଣ ଯାକ obviously ଦି ଜଣ ଯାକ ଯେ ଆପଣ ଦି ଜଣ ଯାକ ଆସୁଛନ୍ତି ତ ଆପଣ ପାଖକୁ ତାହେଲେ ଠିକ ଅଛି the petitioners have been regularized in service as artists by order dated
16/8/2017
with effect from
petitioner number 1 is 7/9/15
7/9/15 into bracket petition number 1
and the other petitioner 31/9/15.
31.09.2015 petitioner number 2.
Both of them
The
are
subsequent developments shall be brought on record by filing affidavit, shall be brought on record by the opposite party by filing affidavit upon serving copy thereof on the learned counsel for the petitioner by filing affidavit by
within a week.
27
Mal.
by 27/7/2026 the matter shall be listed for orders in the week commencing for admission for admission in the week commencing 3/8 for admission. Yes, next. Say order that. সেটা হচ্ছে আমরা বহুত ভুলভাল হচ্ছে আর ওটা লিখন্তু the office note the registry has pointed out typographical error item 23 কে same appeal রে
order number 3 નો ଉପରେ হবা কথা 328
the office the registry has pointed out typographical error that has crept into the order dated 13/5/2026. The same appeal number has been wrongly typed as 128 instead of 328. The numerical 1 shall be corrected as 3 in the said order dated 13/5/2026 in accordance with the rules.
Item number 24.
May I please do not see.
Rest of the matters other day, because we have already crossed in many cases other side will not be there. So 24, when do you want?
Lordship, here the petitioner is seeking transfer of guardianship miscase number 169 of 25 from the Court of Judge Family Court.
No, military argue करते other side nahanti na. After 4:15 it's not.
Lordship, the
केबे
miscase.
आसले हबो? Date.
Ajio Lordship.
Date करते हम 24 टा.
24 टा
Orders.
orders 3/8 पड़ो.
3/8.
3/8.
Lordship, interim order is there.
25 requisites filed, Mr. Chand. 25 Mr. Manas Kumar Chand for the 24 actually ଆପଣଙ୍କର after notice matter.
After notice matter, your Lordship.
Mr. Swain ପଡେ ଗଲେ. ଆପଣ sir Mr. Swain. ଠିକ ଅଛି. Just one second. ମୁଁ ଭାବିଲି ଆପଣ ବୋଧେ କାଳଚରଣ ସ୍ୱାଇଁ. 24 ଟା 3/8 ରେ ବିକ୍ରି କରିଦିଅନ୍ତୁ for admission. ନା କରିହବନି ଆପଣ କମ୍ପ୍ୟୁଟର କରିହବ ତ ଠିକ ଅଛି. 25 Mr. Manas Kumar Chand for the petitioner. It is submitted by the learned counsel for the petitioner that the requisites for issuance of notice to the sole OP has been filed today.
Again.
Filed today in the registry. The office shall accept the same and proceed to issue notice to the opposite party. Returnable date be fixed to. Mr.
Speed
The order date shall be listed for orders in the week commencing 10/8/2026. तो interim order थिला एतरे
आया थिला नहीं नहीं थिला नथिला
अच्छा ठीक अछि.
Lordship, in item 24 there is interim order. That to be
24 कोन थिला कहले post adjournment order.
No, your Lordship. Stay was granted on that day. Your
Stay hele तो it is not remains untouched. The interim order 24 रे कर दियंतु paucity of time intervenes. The matter shall be listed for admission in the week commencing ete. Ete कहले
Week commencing 3rd August.
3/8/2026. Interim order dated
7/5
shall continue
7/5/26, your Lordship.
7/5/2026 shall continue till the next date of hearing. And 26 posting कर दें 26 तक.
Opinion on behalf of the petition item 26 Lordship. Is seek for an adjournment Lordship.
26.
Again.
I mean, we are already beyond time, so
yes, Lordship, because the
date करो.
Again.
26 TRPH
10/8.
Yes, Lordship.
We commencing 10/8. 27.
27 I am for the petition.
Yes, Mr. Singh.
Let's make keep it on Monday match.
Lordship, another TRPC is there, and that is also we commencing 13th of July 2026, your Lordship. Kindly this matter TRPC number
Between the same parties.
same parties. TRPC.
सेटा देखि दो पड़ो.
No.
Let's
अजी साहब को दियो तो लिखी कि एटा 13/7 ने ता संगे आसीबो.
we commencing. Yes, your Lordship.
आपण नंबर न देले से जानिए केमते.
TRPC number 158 of 2026.
TRPC number
158 of 2026.
158 of 2026.
158.
कंप्यूटर चेक कर.
ए आपण को मिस्टर
TRPC is for transfer. In this writ petition, the order of allowing the amendment is the subject matter of challenge. So there are difference. So this may be on
the argument difference on when the litigation between both the parties is better. आपण अलग आर्गुमेंट कर. TRPC जदि जणे चालता ताले मजे जगह रे रहता था. एथरा कोन हो
Monday one.
नै जेबे सेरा ड्यू डेट सेफ्टी कोन करि होबो प्रीपोन करि होबो. आरोटा 13/7 को जदि अछि एटा को 13/7 को रखि होबो एडजस्ट करि होबो. 13/7 वीक रे आपण डिफिकल्टी अछि.
No difference.
से आसु सेम डे रे आपण मेंशन करिबे. आफ्टर नोटिस मैटर उडा को जहा को डेट कर देबे. जोडा को अर्जन ऑलरेडी हेनी.
I pardon my lord.
Yes, Mr.
I'm the last item number 40. Only matter for hearing, and it is coming since 6 months. but it's not issuing.
যেহেতু আপিলটা মিস্টার জেনা আপিলটা ফর আডমিশন আসিব কি আপিলটা হিয়ারিং রে
No,
আসিব
appeal আসবে. If
মানে
your
অর্ডর
lordship
তো হিয়ারিং କରିବାକୁ ପଡିବ କଣ ଅଛି କରିବାକୁ ପଡୁଛି
if your lordship
40ଟା ଗୋଟେ ଡେଟ୍ କର
date କଲେ ସାଙ୍ଗେ ଆସିବ ସେଇ ଲାଷ୍ଟ କୁ ଆସିବ ଆଉ ପଡିବନି. ଗୋଟେ after launch ଯଦି ଗୋଟେ fix any day.
ଆପଣ ଦିଲ୍ଲୀ ସିଫ୍ଟ କରି ଯାଆନ୍ତୁ ଆପଣ ଆଉଟ ଷ୍ଟେସନ କାଉନସିଲ ହେଇଯାଆନ୍ତୁ ସେତେବେଳେ କହିବେ ଯେ ମୋର ସିନ୍ସ ଆଇ ଏମ୍ ଆଉଟ ଷ୍ଟେସନ କାଉନସିଲ ଆପଣ କଣ ଯିବେ ଗୋଟେ କଟକ ଛାଡିକି 3-8 ୱିକରେ ଆସିବ
Item 35 small date because the transfer application is pending.
35 ଟା କରିଦିଅନ୍ତୁ ଡେଟ୍
Short dated.
ପେଜ ୱାଇଜ ଯିବା ଆଗ 28 to 32 କିଏ ଅଛନ୍ତି ମେନସନ 32 କହିଲେ
32 ରେ ଆଜ୍ଞା ମୁଁ ଖାଲି ସେ ଅଥେଣ୍ଟିକେଟେଡ ଇଣ୍ଟରିମ୍ ମେଣ୍ଟେନାନ୍ସ ର ଇଏଟା କପିଟା ଦେଇନି ସେଟା ମତେ 15 ଦିନ ସମୟ ଦିଅନ୍ତୁ ମୁଁ ସାର୍ଟିଫାଇଡ କପି ବ୍ରହ୍ମପୁର କୋର୍ଟରୁ ଆଣି ଦେଇଦେବି
ମୁଁ କଣ କରିବି ମୁଁ ଆଣିବାକୁ ପଡିବ କି
ନା ମୁଁ ଆଣିବି ମତେ
ଟାଇମ ମତେ କିଛି କହିବା ଦରକାର ନାହିଁ
ଟାଇମ ଟା ମାଗୁଛି ସେଇଥିପାଇଁ
ସେ ତ ଟାଇମ ହେଇଗଲାଣି ସେ ତ ସେପଟ 10-8 ୱିକ କୁ ଯାଇଛି ଆପଣ କଣ ବିଶ୍ୱାସ କଲେନି କି ନାଇଁ ଇଟ ୱାଜ ସିରିୟସ୍ when I granted 10-8 it is 10-8 ତ ସାର୍ ମେନସନ କରିଥିଲା ଅଦର ସିଟ୍ ମେନସନ
not had that's
ଆପଣ ଥିଲେ
ନା ମୁଁ ଶୁଣି ପାରିଲିନି ଡେଟ୍ ଟା
ନାଇଁ ମୁଁ କହିଥିଲି ଅଦର ସାଇଡ୍ ନାହାନ୍ତି ଆପଣ ଡେଟ୍ ନିଅନ୍ତୁ ବଟ୍ ବେଳେ ବେଳେ ଅଦର ସାଇଡ୍ 4:30 ଆସିକି କହୁଛନ୍ତି ଆଜ୍ଞା ଆମକୁ ଜଣେଇ ନାହାନ୍ତି ଦ୍ୟାଟ୍ ଇଜ ନଟ୍ ଗୁଡ୍
ଆଉ ମୁଁ ବି ଦେଇଦେଇଛି ରିଟର୍ନ ନୋଟ୍ ଅଫ ଫାଇଲ କରିଦେଇଛି କାଉଣ୍ଟରରେ
ରିଟର୍ନ ନୋଟ୍ ଏଥିରେ
ହଁ ସେ ଗୋଟେ ଦେଇଛି ଆଉ କାରଣ ଆଉ କିଛି ଇଣ୍ଟରିମ୍ ମେଣ୍ଟେନ ଆଉ ଏରିୟର ମେଣ୍ଟେନାନ୍ସ ଟା ଥିଲା ତ ସେଇଟା ମୁଁ ଦେବାକୁ ବାକି ଅଛି
ସବରିମାଲା ନା କେଶବାନନ୍ଦ ଭାରତୀ ରିଟର୍ନ ନୋଟ୍ ଦରକାର ଏଥିରେ
ଦରକାର ନାହିଁ ଗୋଟେ ଯେହେତୁ
ହେଲା ଖାଲି ଡିଲିଟ୍ କରିବା
ଯେହେତୁ ସାର୍ ସେ
ଆପଣ ନିଜେ ଆପଣ ରିଟର୍ନ ନୋଟ୍ ପଢିକି ଆର୍ଗୁମେଣ୍ଟ କରିବେ ଭଲ କଥା
ନାଇଁ ତାର ଇଏଟା ଯୋଉ ଏରିୟର ମେଣ୍ଟେନାନ୍ସ ଟା ମୁଁ ଦେଇନି ସେଟା ଆରେଞ୍ଜ କରୁଛି ଦେଇଦବା ପାଇଁ ସେଥିପାଇଁ ଗୋଟେ ରିଟର୍ନ ନୋଟ୍ ସେଥିରେ ମେନସନ ବି କରିଦେଇଛି
10-8
Milord, I may be excused, Milord.
Yes, sir.
Item 31, the interim order may kindly be extended.
31 interim order कौन चला कहले
Stay of
adjournment date थिला
stay of the impugned order.
जोड़ा को टच हेनी सेडा तो मॉडिफाई हैला कि किछि हेनी आपनकर जदि adjournment date थिवो ताहाले that has to be again the date has to be given
Sir.
एते कोन स्टे अछि ना adjournment date अछि
No, stay अछि.
Stay sir
Stay of the impugned judgment.
You want a date 31 आपन डेट दरकार कि डेट कर दियो 31 ठीक है 10-8 करो 10-8 है week commencing 10-8 yes next page 33 to 39
Let's see, 33, I am for the opposite party. Number
you want a date कर दियो
Yes.
35 to similar.
Okay.
A short date over because and the order was up the interim order continued till next date so let it be
next date माने under no vacation
Your Lordship, item 38, Your Lordship.
just one second 33 टा करले कि आपण
33 टा कर देली
हां डेट कहि दियो से जानि बे ना
33 टा 10
ठीक है
35 short date
35 करो
my friend is also for the opposite party
टोटल 3-8 हो
3-8 है yes please
Your Lordship, item 38, short date, Your Lordship, because matter has been pending.
38 short date question actually there is a pattern in what we are doing up to 10-8 we are having 300 400 about 500 matters already on board directed to be listed that we are trying to distribute and do it so that is how we are going on latter date ଆପଣଙ୍କର जो 3-8 କହୁଛନ୍ତି ସେଟା ଆଜି it has crossed 100 98 ସକାଳେ ଥିଲା 3-8 ରେ so there is a purpose list କରିବାରେ କିଛି problem ନାହିଁ but reasonably ଗୋଟେ ପଢିବାର ଚାନ୍ସ ରହିବା ଦରକାର and if the matter even fresh or orders is not heard କେମିତି ହବ ତା ବି ହବନି so it is a balance delicate balance ଆପଣ 3-8 ଚାହୁଁଛନ୍ତି ନା କେବେ ଚାହୁଁଛନ୍ତି 3 ନା 10 କୋଉଟା ଚାହୁଁଛନ୍ତି 10-8 ରେ 50 ଟା ପର୍ଯ୍ୟନ୍ତ ଅଛି
Your Lordship,
before that ହେଲେ 13-7 145 20-7 141 27-7 133 he is doing his homework because this method I have evolved after I sitting with Justice Pathak because in Guwahati they have been doing this every day you have an idea how many cases are being posted and since you are making it in a week even if an hour or a day is lost but some division bench break bench we are able to adjust it 27 ରଖିବେ 133 ଟା ଅଛି ରଖନ୍ତୁ then the trickiest part is that computer, if it when it is listing, it is automated. ଉପରକୁ ପଳେଇବ 14 ମସିହା ମ୍ୟାଟର, ତଳକୁ ପଳେଇ ଆସିବ 26 ମସିହା ମ୍ୟାଟର. So everything, there is lot of some thought process is going on. May not be perfect, but there is some thought process. କରିଦିଅନ୍ତୁ ଯୋଉଟା ମ୍ୟାଡମ କହୁଛନ୍ତି.
Yes, sir.
ସରିଲା. Thank you.
Recording stopped.